23rd has some personal difficulty, medical emergency. My lord, I'm just seeking, it can be on 27th or any other
What
day.
I told you.
Well, I've got the other joints.
Yes, tell the both the special officer give one date when both will appear.
My lord, any
Otherwise, the court has to pass a strict order.
Yes, my lord, any day. Any day.
Not any date, you tell the date.
My lord, 10th, if your lordship kindly keeps it.
10 this okay?
Yes.
Not on you mention on that day, I will fix the date on 10.
As I mentioned one new application, it was retarded due to retardable today, but the new application has been tagged with item number 168 in the suit. So let that new application be detached from the suit and appear as a new application.
For what? For what?
For new my application for revocation of leave under clause 12, revocation of leave under 12A of the Commercial Codes Act, revocation of leave under 12A Commercial Codes Act,
Okay.
and also part by limitation. So
Okay.
that petition we have already filed.
कौन सा देख लो तो new motion में ले.
Fix it on Friday. May it appear on Friday as a new application.
If you sit here, I will fix that on Friday.
My lord.
If you will sit in this seat, I will fix that.
I'm limited. I'm limited. 160.
My lord's kind leave to mention item number 153 of my lord's daily list, my lord, upon notice to my learned friend. My lord, I appear for the plaintiff, my lord, and in the suit, my lord, I have taken out an application, my lord, which is also appearing in your lordship's daily list, my lord, which is in the nature of an application under order 13A, my lord. If it so commences to my lord will...
it will come as in the new motion, it is suit.
It is supposed to come as new motion,
okay,
and as per my lord's convenience, whenever my lord's...
Come in the new motion.
My lord, may I also, my lord, point out that this application is based on the premise that no written statement has been filed, but we've preferred a GA2. My friend's application is GA3. GA2 is for the extension of time for filing written statement, and it has been filed before 120 days, my lord, subject
to not,
leave.
My lord.
Leave has been granted, it's filed in the department.
My lord, lordship.
My lord may take up, my lord, both together. Then, my lord, because my lord, the application proceeds on the premise that there is no written statement. But if my statement is true, then this application effectively becomes infructuous. So kindly, my lord, let both applications come. I'm not opposing the mentioning.
When you file the GA2?
My lord, GA2 has been filed, my lord, more than a month ago.
So why you are not mentioning if you filed?
It is running on the list, my lord. Both the matters are running on the list.
My lord, I'll just tell your lordship, just brief background of the story. My lord, what had happened? My lord, my learned friend's client filed GA2. My lord, which was in a matter, my lord, in a nature of an application, my lord, seeking an order from your lordship to file their written statement after, my lord, filing of the application. My lord, it is not, my lord, that the written statement was filed along with the application. Thereafter, my lord, my learned friend's client, advocate on record, gave me a notice, my lord, of mentioning, saying that they'll be seeking upgradation of the matter, my lord. My lord, the mentioning notice was given to be, my lord, my learned advocate on record by way of email. Somehow, my lord, I missed the mentioning, my lord. When my learned friends, my lord, mentioned the matter.
Let all GS come up.
Okay.
Lordship will decide on that day what to hear first.
Fix on that new motion. कब कल आएगा परसों आएगा कल. Tomorrow it will be in the new motion list. And we'll
tomorrow I'm in some difficulty, my lord. Kindly, my lord, keep it next week, my lord, subject to the
next week.
My lord, kindly keep it next week, my lord, please.
In fact, my lord,
because
my
lord,
friend
I
has no right of audience, my lord.
Of course, my lord will decide.
18th को कर दो. 25th.
I'm so grateful. So grateful.
Grateful, lord.
All GAs, my lord. Grateful.
ये ले लो. Hello.
Lord, there was a plaint, my lord, that I had attempted to present on the last occasion, and my lord was pleased not to give me a leave under 12A. However, my lord, there has been an incorrect finding which has been recorded in the order.
What?
I'm praying, my lord, I had said, my lord, the defendant had admitted its liability to the extent of 75%, but in the order it has been recorded that the plaintiff has agreed to pay the amount. The order copy is on it. If lordship can keep it.
Plaintiff is agreed to settle the issue by 75% of the amount.
No, my lord, that is not. It is recorded that the plaintiff has made this offer. I have not made any offer. If lordship can keep it for not to be mentioned tomorrow, my lord, I can bring the order. It's a formal correction.
Where is the order?
Lord, I was waiting, my lord. The order has not come to me. I have a soft copy, my lord. If number I can tell. It was CS 110-2025.
Give the soft copy then.
Lord,
Okay, bring come tomorrow. We'll see to that.
Yes. Lord, I permitted to mention. Lord, seeking lordship's leave to file an application. Lord, the affirmation is otherwise correct. 7 accepted typographical mistake. I'll show you lordship. Lord, I have, according to the affirmation part, The department is not accepting it, my lord.
What?
The affirmation part, kindly come to the last portion of that page.
Contains in
my lord.
paragraph.
Yes, that portion is kept blank because my lord, in the next sentence, 1 to 10 have been my lord affirmed. All paragraphs have been affirmed subsequently. But there is a repetition of that sentence in the above. So department is not my lord accepting that. So kindly give me leave to, that sentence has come twice. That's the otherwise all paragraphs are,
But it is affirmed before the outcome. It
it has come from outside.
yes,
It has come from outside. That is the leave I am seeking, my lord, to file it in the department because it is an application for acceptance of written statement. Written statement is also affirmed and has come from outside. It is not my lord, drafted or prepared by us. It has come from outside, my lord.
So how you can correct the statement contained in paragraph dash to dash of are true to best of my knowledge.
Yes,
So you
but-
want to delete that
Yeah, it is not true to my knowledge. It is only based on my lord, the subsequent line that is written.
paragraph 1 to 2 and are based on. So the two line is to be deleted.
Yes, first line is to be deleted. The portion which is
Made
kept
in
back. Now
paragraph.
I can't delete it because it come from outside. But department is not accepting it. So they have to basically ignore it. If lordship gives me leave to file, with that leave I can file it in the department.
What?
Lordship gives me the leave. Leave will be my lord, endorsed by lordship's officers, my lord. Then I will be able to my lord, file it in the department.
Leave is granted. Leave is granted to the plaintiff to delete the sentence starting from in paragraphs dash TO2 of the foregoing petition are true to the best of my knowledge and those contained in कहाँ से कटिंग किया बोला contained in paragraph paragraph 2 page number 11 of the affidavit portion to the foregoing contained in paragraph that to my knowledge and those is to be deleted granted leave to be deleted is to delete in course of the day.
And not same in the connected application for condonation of delay. Same problem.
Same thing in the connected GA number 76.
Same problem. The page number and the
Page number 6, paragraph 2. Start from contained in paragraphs dash to dash of this foregoing paragraph to the best of my knowledge and those. We delete.
Lordship,
Let me
Lord, I apologize, my lord. I've got the copy of the order, Lordship.
Tomorrow.
Lord, paragraph 4 and paragraph 9. Tomorrow, grateful, my lord.
Yes.
Under compelling circumstances, I have been mentioning compelled to.
If I think the court will continue for mentioning, it will till 4:30. The mentioning will continue.
Pardon me, my lord.
You are in the road. You have just 38 taking the mentioning. Then you are coming from the road.
My lord, pardon me, my lord. Under compelling, because one matter, my lord, issued warrant of arrest against the Postmaster General, my lord.
Yes.
The problem is that, my lord, that is not his fault because he has given entire things to me, but I have missed the list. My lord, that is entirely, my lord.
Then
My
why
lord,
you are not appeared?
My lord, that is my fault. I cannot develop, my lord. My lord, I cannot develop that, but everything he has given to me.
When is the date fixed?
22nd.
Huh?
22nd, my lord.
Come on, 22nd.
My lord, I am for only Postmaster General. My lord directed me to take a my lord, report. I have collected the report and report with me.
But he has to present.
Yes, my lord.
He has to present before this court. Warrant is issued. Okay, warrant he will not be produced.
Yes, my lord, that is my lord, my fault, my lord, because he is not my lord, because he has given entire thing to me, my lord. Because earlier, I missed the list. That is my lord. I cannot develop that. I'm praying for unconditional apology before your lord.
Correct. Come on 22nd, but he has to be your Postmaster General is to be present here. Postmaster General not. To against whom the warrant was issued.
My lord, Postmaster, my lord, warrant Postmaster, my lord, General, Post Office, and my lord, against 5%. 6
By an order,
I am only for the Postmaster General.
Acha, that person. Yes, sir. This matter I will not leave. Sorry. This matter I will not leave your Postmaster General. You are playing with your authorities are playing with the court.
No, my lord, they are not.
With the connivance with the other party.
No, my lord.
Yes,
Even, my
the
lord,
court has passed an order in the month of March or November 2024.
my lord, that is my lord.
Then
My lord, that is my
the
lord.
Postmaster General is not, and you are not have, and so many dates the matter has been listed. You are not
Yes, my
noted
lord,
the
that is
date.
my lord. My
Sorry, come with the arrest. I will see to that.
my lord, I paying for unconditional apology, my lord, because when the matter was called on, my lord.
So since November, why you are not postal authority? Why they are not giving it the total details?
My lord, they have
In
given
connivance with the other party,
No,
and
my
this
lord,
is the
they have-
probate matters.
my lord, they have given the details, my lord.
To whom?
My lord, to me, my lord.
Where is the report?
My lord, if my lord desire, my lord, kindly fix.
Where is the report you have submitted?
My lord, report is with me, my lord. If my lord directed me to file an affidavit, I shall, my lord, file it.
What director do? Can you see the order?
Yes, my lord, I shall, my lord.
What further direction is required?
My lord, you report is with me, my lord.
Come on, 22nd.
Obliged to my lord.
Lord, I'm for the defendants in this matter, my lord. My lord, in this
Yes.
matter, witness on commission was going on. At
Yes.
that juncture, my lord, I found that certain additional documents had to be produced. I have
Hmm.
put an application before your lordship.
Hmm.
My lord, my learned friend on the other side had sought for time to file affidavit in opposition. That application is pending. Now, in the meantime, what has happened today? Why the matter has come, my lord? Possibly because the learned commissioner was to file his report today. But my lord, this is pending, so that mandate, my lord, I was humbly praying if it could be extended.
Hmm.
Application will be.
The application is made returnable on the 27th. Unless that application is decided, there is no.
Who has filed? You filed an
I filed
application
an
for
application,
additional
my lord.
documents.
The
In
defendant.
the commercial matter.
My lord.
Yes. We had sought for time to file affidavit. We are out of time. We have still not filed the affidavit.
Yeah.
But that is returnable on 27th.
Hmm.
In the meantime, extension of
So
the
in
mandate.
that day you will file affidavit. Then he will file reply.
We'll try to file it within 2 days. My learned advocate on record was in hospital for 3 weeks. But any event.
If that time also could be extended to
Yes,
maybe
if
we
that
can.
could be done,
continue
then
the
on the
process.
joint prayer, if your lordship could.
Yes. 27, na? Let it come on 27 along. No, this is to be mentioned.
To be mentioned.
Okay, not the matter is listed as to be mentioned for filing report by the commissioner. It is submitted that the witness whose witness is going on before the commissioner?
My witness was supposed to begin. The defendant's
Not yet
witness.
started.
Plaintiff's is over. Defendants was supposed to start. I found
Your
documents.
witness is not started.
No, not started.
By the commissioner today. It is submitted by the learned counsel for the parties that the plaintiff witness is over and the defendant is supposed to adduce the evidence, but the learned counsel for the defendant submit that at the time of preparing the examination chief on affidavit, the defendant found that certain document has not disclosed. Accordingly, the defendant has taken out an application
GA4
due to disclose additional document, and the said application will be appearing before this court on 27th of August 2025. In view of the above, time to file report by the commissioner is extended till, I don't know when this application will be disposed of. Okay, for the time being till 29th of October 2010 till 4th of November 2025. Release the matter on 4th of November 2025. Filing report by the commission.
But in GA4, if your lordship.
That will come on 27th.
Great.
In this matter, I am appearing for the plaintiff matter.
Yes.
May I file my report, madam?
Lord, I appear for the dependent.
Completed examination completed
Yes, my lord.
of both the parties.
Yes, my lord. Plaintiff was completed earlier, my lord.
Yes,
Defendant is also
earlier you
completed.
filed.
I have filed my report, I have circulated a copy also.
Circulated. Yes. So no further evidence.
No, ma'am.
Learned advocate, have you paid the, you received the remuneration? Learned commissioner is present and filed report. After serving the copy to the learned counsel for their respective parties, let the report be kept with the record. It is submitted that evidence of both the sides has been completed. Counsel for the parties submitted that they will not adduce any further evidence. In view of the above, evidence of both the sides is closed. Full stop. Let the matter appear on 10th of September 2025 for argument.
My lord, except 10th, my lord, 11th, can you be kept, my lord?
16th of September 2020 for argument. As the learned commission has submitted the report, accordingly, he has been discharged as commissioner from the instant case.
Your Lordship,
Lord, I appear for the
Your
defendants.
Lordship, this is regarding that matter, Your Lordship, where we could not file the statement and truth and all the documents, Your
Ah.
Lordship, because of the Wakalatnama issue, Your Lordship. The Wakalatnama was filed, but now they are not taking the documents because it was affirmed by the erstwhile post holder, Your Lordship. But at that time, when these documents were prepared, Your Lordship, Wakalatnama was affidavit of competency was made by the one who was affirming these affidavits, Your Lordship. But according to the department, since later we had filed the affidavit of competency of the present incumbent to the post, Your Lordship, this cannot be accepted, Your Lordship. But in the meantime, Your Lordship, we had served the copies to the other side, and then, Your Lordship, they had filed the written statement, and Your Lordship, then the inspection, discovered the inspection was going on, Your Lordship. The plaintiff's document.
You are not filed the further Wakalatnama and affidavit competency. You filed.
We had filed, Your Lordship, but that is, Your Lordship, the present
Present
post
advocate, not
holder.
the last occasion.
Yes, Your Lordship, but it's regarding the affidavit of competency was made by the present post holder, Your Lordship, because the one who had affirmed the statement of truth and all, he has retired, Your Lordship. So the affidavit of competency that was filed subsequently pursuant to Your Lordship's leave was granted, Your Lordship. It was by the present incumbent to the post, Your Lordship. So this was affirmed by the erstwhile. So they are not taking it, Your Lordship. Your Lordship, I was praying for leave to
So
file these documents.
what about the discordant inspection?
My lord, in
It is
discovery and inspection, the plaintiff-
our
the
documents
defendants have
completed.
inspected all the documents of
Now
the
they
plaintiff.
will
Now
give us
we shall
leave.
offer them inspection. I do not know whether they'll be will you be filing any fresh plaint or anything?
I don't know. It's depends.
My lord, if my learned friends file a fresh
Because-
plaint, then we'll have to file a fresh
Plain. Why fresh plain?
Your Lordship, only thing is that, Your Lordship, the documents, the statement of truth and the list of documents and all has to be affirmed by the. If
Because my
the
lord,
leave is not
we
granted,
appreciate
then
it
it
has
has
not
to be
become an
freshly
official suit
affirmed.
yet. Although the number is there, but the plaint has not yet been made as per the
Doing,
commercial
madam.
suit. Although they have obtained leave in January.
2024, the commercial,
Yes, my
now
lord.
25.
Your Lordship,
18
and
filed
this
the
has
suit.
been affirmed in January, Your Lordship.
some
And
First, Your Lordship, the
a-
documents that we wanted to
And
file.
Ministry of Railway,
My lord.
the officers are here only.
If the
So why
plaint
you're
is
not
not as
taking
per the
all
commercial
the,
code,
why you're not taking the
it's defective.
instruction from your officers at a time?
Your
I
Lordship,
know the officers, the IPS, IRS will not come to your office.
Your Lordship,
The
this
peons
was
will come
affirmed,
to
Your
your
Lordship,
office.
pursuant
I
to the
know.
leave, Your
But
Lordship,
the
this was
defendants
affirmed in
prepared a
January,
written
Your
statement on
Lordship.
the basis of what we had
That
been
is the
served.
problem you are
And
facing,
it's
but you have
served,
to
Your
be
Lordship.
strict. Unless until the panel advocate will not stick, the officer will dance in your head.
I leave it to your lordship. We had prepared a written statement on the basis of the
They have already
they have served
Your
us, but
Lordship,
they have
and
not
then,
filed
Your
it in the
Lordship,
department.
1 year has been passed. You are not able to file the affidavit of
Your Lordship, this was
competency.
affirmed in January, Your Lordship. Then, Your Lordship,
Every time, every 3 months, either your officer will be retired or your officer will go on leave or will transfer, whatever it is. And you will face the same problem. Okay, I am fixing the concerned officer to come before this court. All the things will be done in a day.
Your Lordship, we can get it if Your
I will
Lordship.
let the officer come here. He will affirm the affidavit in presence of the court.
Your lordship, this
Because
affidavit was
for one
affirmed.
and a
Your
half
lordship,
year, your officer is not able to
no, your
come.
lordship,
So
this,
let I am passing an order. Let he come here
your
and he
lordship,
affirm the
this was
affidavit of
affirmed in
competence.
January, your lordship, pursuant to the order passed by this court. This was affirmed, your lordship. But when we went to file it, your lordship, the documents that we were relying upon, your lordship, it was not
Counsel-
photocopied
Counsel
correctly.
for the plaintiff submit that the earlier officer of the plaintiff who has affirmed the affidavit of competence, Vakalatnam and affidavit of competency has retired, and as such, she requires further time to file a fresh affidavit of competency, statement of truth, and
Your lordship, fresh affidavit of competency has already been filed, your lordship.
so
in
what
the
do you
court.
want now?
Your lordship, the department is not taking the statement of truth and the other related documents that were affirmed in January by the erstwhile officer, your lordship. I'll just tell the name, your lordship.
For the new one, but the
Kamarapuram Subramaniam Anand.
Hmm.
He has affirmed on 24th of January.
So why you not file that?
Your lordship, the documents that were annexed to your lordship were voluminous. Your lordship, they had photocopied. They didn't want to give the originals, your lordship, so they had photocopied and given to us. When the advocate went to file it, it transpired, your lordship, in
Correct. So that the office is correct. Now you are filing the document. And now when you are filing the document, on that day the officer has to affirm the affidavit. Who will take the
your lordship.
responsibility?
That's what the department is saying, your lordship.
So you file a fresh. How much time will take for filing this fresh statement of truth?
Your lordship, only I
File the
think,
affidavit of competency.
Fresh everything.
You file the affidavit of competency.
Yes, your lordship, it has
You
been
filed.
filed, your
So
lordship.
there is no problem in the affidavit of competency.
No, your lordship.
Only stated the truth.
Yes, your lordship.
My learned friend is also filing a fresh plaint, I think.
Your lordship.
They're carrying a,
How it can be?
they're carrying a fresh plaint.
Documents, your lordship, because this was transferred from the suit court to the commercial.
There's no necessity to.
My lord, from what I understand is that
Lordship,
after the
that's-
transfer, after the order of
They
transfer
we
from
have to,
non-commercial
your
to
lordship.
commercial, the plaint has not been prepared as per a commercial suit yet. That is the difficulty.
Because we have
Now it has been
served.
prepared. They have served
We-
us, but they have not been able
We
to
had
file it in the
prepared, your
department.
lordship, and we
They
had
have been
served
filed.
in January, your
They
lordship.
have
But we
served
couldn't
us. They have not
file
been able to file it in the
the
department.
documents, your lordship, that because in commercial code, your lordship, the documents we rely upon, we have to give, your lordship. The photocopies they had given, your lordship, it was on both sides.
Now
your
what
lordship.
you want?
My lord,
Your
perhaps
lordship,
as per the court's records, the suit has not yet been made into a commercial suit. They will have to file it in the department and reaffirm it, perhaps.
Your
Only
lordship.
she has to reaffirm.
Yes.
All the new print. Only reaffirm the front and back paper.
Yes, and all
Yes,
the
your lordship,
statement of truth
the
and all the
statement of
documents
truth
that
and
they
all the
rely upon.
documents, your
Because
lordship.
the commercial
It's okay,
So that is what they are filing, my lord. They are carrying the plaint, I can see. They're carrying the plaint.
It's your lordship, all the plaint, the statement of truth, your lordship, the list of documents. না already inspection হয়ে গেছে তো। না কিচ্ছু না।
And the statement of truth. And the statement of truth. Right. Get it. Only the statement of truth and the amended plaint.
Yes, your lordship.
In terms of
The
you want to file.
amendment, your lordship, the cost title and only the cost
Counsel for the
title.
plaintiff submit that after the transfer of the suit from the non-commercial division to this court to the commercial division, the plaintiff is to be amended. Accordingly, the plaintiff has taken appropriate steps for amendment of the plaint in terms of the Commercial Court Act, and also affirm the statement of truth. The statement of truth also
All your lordship.
also
All
affirm the
affidavit of
affidavit of the
24th
statement of truth. So what do you want?
Your lordship, either this can be filed, your lordship.
Already affirmed. Already affirmed.
Yes, your lordship.
When it is affirmed,
Your 24th January, your lordship.
they will not. Now you have to.
Then we have to reaffirm, your
क्या बोला?
lordship. So that time has to be given.
Plaint,
Teacher.
along with the affidavit of the
Mother Baba
she submit that the said amended plaint and the affidavit of the affidavit in the statement of truth was affirmed in the month of January 2025.
January 24, 2025, Your Lordship. This has been affirmed,
But
Your
now
Lordship.
the department is not accepting the same as the said officer has been retired. In view of the submission made by the counsel for the plaintiff is given liberty to affirm the first affidavit of the plaintiff as well as of the statement of truth within a period of 1 week.
My lord, if my learned friends are permitted to reaffirm and re-verify the
They-
plaint, then the defendants will have to file a written statement to that reaffirmed and re-verified.
If there is any
Your
change,
Lordship
can
will
grant them
kindly
the
grant
liberty
us
to
leave
file
to
the
file
plaint which
these
they have already
documents, Your
affirmed.
Lordship.
yes,
Your Lordship will kindly grant us leave to file these documents because these documents have the affidavit of competency and the wakalatnama
correct, I
as
am
of
allowing how much time?
এটাই যদি ফাইল করেন এটা
this we will file. This we can file if we don't have.
Affirmation is the your new officer has to be affirmed, not with the earlier. So that's what time you required.
Your Lordship, 10 days.
Within 2 weeks, after serving the copy to the London Council for the defendant,
কপিটা তো করতে
after serving the copy to the London Council for the defendant, and the defendant is at liberty. So you are already filed the written statement.
statement as per the earlier version of the plaint.
Correct.
Which was
If
served.
you find anything, then you mention that.
Very good, very good.
After serving the copy, let the matter appear on 9th of September 2020.
Parties are directed to complete
Your
the
Lordship,
formalities.
this
In the
was
meantime-
directed to appear on 22nd, Your Lordship, for suggested issues, Your Lordship.
In the meantime, the parties are directed to complete the inspection
Yes.
and discover in inspection and to exchange their suggested issues.
Great.
9th September for framing of issues. Yes, next. In view of the above, respondent number 1 and 2, their men, agents, servants are assigned and restrained from giving any effect to the said notices till 17th of September 2025. This court has made it clear that the interim order passed the interim order as the application filed by the respondent number 1 under section 7 of the IPC is not admitted till date. The tribunal is free to take decision with regard to the admission of the application filed by the respondent under section in accordance with this.
Very good.
Well, I am for the award holder.
Yes.
Well, just to refresh your memory, Malad,
Yes.
kindly have a look at my last day's deposition.
Yes.
The witness was not volunteering on last day.
Yes.
So your lordship started, Malad, the examination.
Yes.
Lordship sees, Malad, question number 25 and 26 of lordship's deposition of last day.
May I comply with my lord last order?
You are appearing now.
My lord,
You are appearing.
unfortunately,
Yes.
my lord, I am appearing in only in the first matter. My lord, rest, my lord, my learned colleague is appearing. My lord, may I file the my lord, the affidavit of assets, my lord, which my lord,
My lord, I will demonstrate, my lord, hide and seek going, my lord, game going on here. My lord, kindly have a look at lordship's question put to the witness, question number 25 and 26.
Let me see
Copy
the-
of the deposition if lordship have. Well, the witness was not answering any question which I asked. Then, my lord, lordship sees question number 25.
Yes.
Who authorized you to come to court? I went to office. I found one Sumit Patro, Vijit Dey in the office. They have advised me to file the affidavit. Who are Sumit Patro, Vijit Dey? Sumit Patro, Vijit Dey are the shareholders. When I had a company to the said person. The residential address, lordship asked, I don't know the address. What is the office address? Do you have? So this is on the basis of this. Well, lordship passed last day's order, July 22, 2025. May I place that order before you, lordship?
Yes.
Lordship sees paragraph 3. During cross-examination, the court finds that the judgment debtor is suppressing several things and hiding actual persons who are involved in the company
and also suppress material facts by making false evidence before this court. During the evidence, it has come to know that there are other persons involved in the company who are running the business at present. It has also come to know the company is having 5 ships. It's not relevant. Next, company come to the next. In view of the above, the judgment debtor has given another chance to file accurate affidavit of assets stating all the facets and details of person who are involved in the business of judgment debtor company, and by serving to the decree holder. Now, my lord, kindly come to the affidavit.
Yes.
Filed today. Who has? Now, my lord, he files. My lord, the Pankaj Jain, the witness on last day, he files. Now, my lord, straight away, come to page 5 of the affidavit.
Yes.
The day-to-day business activities are conducted by Pankaj Jain. My lord, has your lordship got that?
Yes.
So that is the only answer given.
Yes.
So, my lord,
পরেরটা পড়ো along read the entire paragraph.
along with me, there are other director absconding from long time. I am not contact with him. But what are their names? You have stated the names before this honorable court. Yes. My lord, I am leaving it to your lordship. My lord, what steps, my lord, lordship, in this view, my lord, lordship is going to pass. My lord, I want, my lord, from whatever records, 3 names are before your lordship.
Yes.
This Pankaj Jain is knows nothing. One is Shumit Patra, Abhijit De, and Navnit Jain. These 3 persons, my lord, may be called, my lord, to file their affidavit disclosing their personal assets, and my lord, allow us to, my lord, examine them.
For a company person as a director can be called.
Shumit Patra, Abhijit De, Navnit Jain. Because, my lord, I tell you, lordship is a claim in 5 matters is around 7 crore.
Yes.
And my lord, a hide and seek game going on. I will prepare a list of this and submit to your lordship, and how they have evaded.
Sir, they have evaded. That's why court has taken.
Lordship,
but there is some duty upon the decree holder. If you want that your amount is to be realized, you have to work hard.
Lordship, I will file then. Well,
only by examining the judgment debtor telling that the so and so, so and so, so and so, so and so, and there is nothing with me. So not now, and you're telling that it will not. So you have to take steps. You have to ascertain what are the, because you have to realize the amount. You want, I will send the person. I will further. I will call and I will sell the person, and you have to bear the cost of the person in the prison.
My lord, Navnit Jain is a director. My lord, Navjin Jain, admittedly they are director.
Whatever it is, you take steps.
My lord, I will file an application to that effect. I will file an application to that effect, my lord.
You file the affidavit in terms of the CPC though?
Of the last order.
CPC though?
Supplementary affidavit তোমার হাতে ছিল, তোমার হাতে দিলাম যে, তোমার হাতে দিলাম তো সাপ্লিমেন্টারি এটা তাহলে তুমি দিয়েছিলে নামগুলো তো।
Form 16 or something
yes,
like
Form 16. You declare all these things. Form 16.
I have may I have kindly comes to paragraph 10I. He has said that he was there with one other director, maybe Navnit Jain. He is absconding. He has no contact with him.
Correct.
Now, the assets, whatever he could have, he has stated, if kindly see paragraph 29, page 8. He has given the entire, even I have seen this affidavit, I have seen. The entire, I was there, when section 34 was filed, in the meantime, I was discontinued. Now, the section 34, we had challenged before this court, we were dismissed on the ground that more than 120 days. So, not on merits, on the point of whatever threshold. Now, paragraph 29, I have asked him, he has come to me, I have asked him, whatever is the assets, if my lord is saying, you have to disclose. He said that more than this, I am unaware of everything.
Okay.
I am unaware of my lord. If my lord wants, my lord can call him again, but the purpose.
You file the affidavit in terms of Form 16. Then if this court find it is correct, it is not correct, then the consequence will fall.
And also, my lord, in terms of 10 June order 2022, Navnit Jain was also directed to file affidavit, which he did not file.
So you take steps. Is not
my lord, pass a direction, my lord, on. My lord, kindly have a look at the order dated 10 June 2022.
Sir, you have to do something.
Lordship, I will.
All the thing cannot be done by the court on your behalf.
Lordship, I understand.
In terms of the order passed by this court dated 22nd July 2025.
Also, kindly also considers paragraph 26 also at page 8.
Okay, that I will see to
Yes.
that. क्या बोला? 2025. Mr. Pankaj Jain, being one of the principal officer of the judgment debtor, has filed the affidavit. This court finds that the affidavit filed by the judgment debtor not in accordance with form number 16 capital A of order 21, rule 41 within bracket 2 of the CPC. Accordingly, Mr. Pankaj Jain is directed to file a fresh affidavit in form 16A of order 21 rule 41 within bracket 2 of the CPC within a period of 1 week from date after serving the copy to the learned counsel for the degree holder. The counsel for the degree holder submitted Mr. Pankaj Jain has suppressed several things and there are other several persons are involved in the company, and by an order dated
Lordship is 10th June 2020.
by an order dated 10th June 2020. 10th June
Navneet Jain was
2022. This court has also directed Mr. Navneet Jain to file affidavit of assets, but no affidavit of assets has been filed. If any of the persons have not complied with the order passed by this court, the petitioner is at liberty to take appropriate steps on the next date fixed.
I'm
This is
grateful.
the matter on 28th of August 2025.
Lordship, I'm grateful, ma'am.
Can it be one day, next week thereafter,
3rd September.
3rd September.
Lordship.
Will my lord record that I've complied with my lord? Maybe my lord is not
Recorded.
satisfied, but
I recorded.
Wait.
First that I recorded, but I find that it's not in accordance.
Complied. My lord,
I'm grateful, ma'am.
he has come to me, my lord, but I've seen my lord, records are not well. My lord, when my lord, I was there, my lord, for a long time. In the meantime, my lord knows my lord, yes.
You were there from the beginning.
From the beginning, but
Yes.
my lord, thereafter, my lord, knows why advocates are discontinued.
My lord, all are same. My lord,
Yes, also
5 to 9.
5 to 8,
Lord.
9. Yes.
I pray for the plaintiff petitioner, my lord.
Yes.
My GA1 for interim relief.
Yes.
There is a GA2 under section 8 for stay of the suit. My lord, if they want to press their GA2, they can. Otherwise, I'll press my GA1, my lord. It's up to
No,
them.
that's why when Mr. Banerjee will be there, when the date is fixed.
25th, Lordship.
Okay, you complete your
I'll
GA1,
complete my GA1.
and if you want to give the reply to the GA2, you can also give the reply. So I will hear Mr. Banerjee on both counts.
Please, my lord.
Yes, Lordship.
Your lordship will kindly have GA1, please, my lord. Give me a second. My lord, the genesis of this matter starts with, my lord, a share purchase agreement relating to the shares of defendant number 1.
Yes.
My lord, the defendant numbers 2, 4, and 6
Yes.
entered into a share purchase agreement
Yes.
dated 24th March 2011 with the shareholders of the defendant number 1
Yes.
to purchase their shares. The intention was, my lord, to take control of the defendant number 1,
Yes.
which is the lessee of a valuable property at the Esplanade intersection, 5A Jawaharlal Nehru Road. This was a lease which the defendant number 1 was enjoying with a right to construct and sublease. So defendant numbers 2, 4 and 6 wanted to exploit that leasehold interest by taking over defendant number 1, constructing a multi-storied building and subleasing it out. Now, if your lordship kindly takes the agreement once, please, my lord. Kindly have. This is the agreement at page 35. The parties are, my lord, your lordship will see the first parties are the shareholders of the defendant number 1.
Yes.
Which your lordship will find till page 36. About 10 lines from the bottom towards the left, your lordship will find first part over there.
Yes.
So there are the 12, these are the 12 shareholders of the defendant number 1 who are parties of the first part. All these, my lord, are parties to this suit also. Then, my lord, lordship will see Orbit Towers Private Limited, who's the defendant number 4. Jagrati Tate Services, defendant number 2. Damani Infracom, defendant number 6, who are the transferee shareholders of the second part.
Yes.
And then James is, my lord, the company which is to be taken over, which is the defendant number 1. Now, the purpose of this agreement, my lord, was to take over the shares of the defendant number 1, which your lordship will find at paragraph 38, please, my lord. At page 38, page 37 onwards, please. Kindly see page 37, recital C. The transferor shareholders have, with the prior permission, concurrence and ratification of the board of directors of the company, agreed to sell all the transferee shareholders their entire shareholding of 36,278 shares in the company. Full particulars mentioned here in above, in the schedule here in below, as a said shares with the entire control and management of the company and with the company's specific assets. The cash and bank balances as may be remaining at the time of completion of the transaction. And this is the important part, Malad. The leasehold right, title and interest into and upon premises number 6 Jawaharlal Nehru Road, together with all buildings and structures thereon, as hereinafter collectively referred to as a property, in a state free from mortgage, pledge, lien, charge, hypothecation, right to set off or counterclaim, etc. So this was, Malad, the sum and substance of the share purchase agreement between the parties, between the defendants. Now, Malad, this agreement continues till page 78. This was an agreement of 24th March 2011. Now, kindly see page 79, please, my lord.
79.
79. Between the purchasing shareholders, my lord, there was a revised understanding. Your lordship will kindly come to 79.
Yes.
Revised understanding between DSM. DSM, my lord, is Dilip Singh Mehta, who's the respondent number 4. I'm sorry, my lord, respondent number 5. Your lordship sees DSM over there is the respondent number 5, who is the person in control of the respondent number 4, Orbit.
Okay.
Then JS is, my lord, the respondent number 2, who is in control of the JS is the respondent number 3, Jagdish Sarda, who is in control of the respondent number 2, Jagrati. And, my lord, PD is Damani, Prakash Damani, respondent number 7, who's in control of respondent number 6.
Yes.
Now, this is the revised, I'm sorry, my lord, this is the revised understanding of 28th March 2011.
Yes.
The investment base, your lordship will find, see over there, 82, these are figures in crores, my lord. 82 crores plus 5, 87 crores. This plus 5, my lord, is a cash component which is not reflected in the agreement of 24th March 2011. Agreement of, yes, this plus 5 was a cash consideration which had to be paid.
Earlier it was only 82.
It is reflected, it was always 87, but only 82 is reflected, and here the actual detail is captured. So 82 plus 5, 87.
Yes.
Then your lordship sees funding pattern, promoters. These are the promoters, my lord, 30. Borrowing, private equity investors, 57.
Yes.
Original promoters sharing ratio. Now here, my lord, they changed the ratio. DSM was initially under the agreement, DSM 40, JS 40, PD 20. Now revised promoters sharing ratio. DSM, that is Orbit, and DSM 46. Jagrati and Jagdish Sarda 36. Damani and Damani Infracom 18%. So they share the 100%. Yes, the 100% division is altered. I come after this. Now your lordship kindly sees promoters to bring 30 as their respective revised ratio. DSM and JS are equally responsible for arranging 50 from private equity, bank, investor, joint venture partner, new promoter. PD will extend necessary support to them. DSM shall arrange for balance 7 from so-and-so. Okay. Realization from building salvage, save as modified hereunder, the terms and conditions of the understanding dated so-and-so shall remain in full force and effect and be applicable mutatis mutandis.
Yes.
This is dated 4th of August 2011. Now, my lord, your lordship sees now, Jagdish Sarda was to bring in 36%. His shareholding is 36%. He has to bring in equivalent payment for 36%. Well, the defendants represent to me that Jagdish Sarda does not have the funds to bring in 36% of 87 crores. So you come in his place. He will offload 50% of 36%, which is equal to 18% of defendant number 1 to me. And that is why this now memorandum of understanding is executed. Kindly see the next document, my lord, at page 80. This your lordship has seen when we were dealing with GA3, my lord. Page 80, please, my lord. The next document.
Yes.
This memorandum of understanding made this 21st day of June 2012 between Jagrati, my lord, who is the defendant number 2,
yes,
transferor, Tirupati Vancom Private Limited, transferee, who is the plaintiff,
yes,
and Orbit Towers Private Limited, who is R4, and Damani Infracom Private Limited, R6, confirming parties. So, my lord, two things here, your lordship will find. Neither the company nor its shareholders are party to this agreement. But they have full knowledge of this, which I'll show your lordship later. Now, this is the recital is there. Now, kindly come to paragraph 3, paragraph.
So at the time of execution of the MOU, this revised was not shown to you.
It was shown. All these were shown to me. My lord, no, I'm sorry, my lord, your lordship. One page is inadvertently missing here. May I just hand over to your lordship, my lord? Page 2, after page 2, it's page 4. May I just hand over page 3 once, please, my lord?
Of the agreement?
Yes, my lord. While photocopying, it seems one page was missed, my lord. The complete agreement is annexed by them in GA2. Kindly permit me, my lord, to hand over page 3 once of this agreement. I'm sorry, my lord. I'll replace the page, my lord, in the fourth screen. Page GA2 ta dekho. Page 3 of the agreement.
Yeah. Hey, Manoj. Hindu. Temple.
कॉपी पेस्ट कर देख
ना
देखा था तो
नीचे 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 नहीं
बैठ जाओ
yes, page 3.
Page 3, kindly see paragraph 1 at the bottom of page 3. I'm not troubling your lordship with the recitals. The transferor, my lord, is Jagrati R2 has agreed to transfer and assign, kindly see, agreed to assign and transfer its rights and benefits of its contract with the present shareholders under the share purchase agreement to the transferee to the extent and to the effect that the transferee shall acquire out of the proposed transfers allocated shareholding 18% of the total equity shares of the company held by the present shareholders, and the transferee has agreed to acquire the same at or for the consideration on the terms and conditions hereinafter contained.
Yes.
To effectuate such assignment and transfer, the transferor has agreed to cause to be transferred by the above named present shareholders out of its proposed allocated shareholding agreed to be purchased by the transferor from the present shareholders under and in terms of the said share purchase agreement 18% of the total equity shares of the company held by the present shareholders directly in favor of the transferee by nominating the transferee to the present shareholders to complete the transfer of such 18% shareholding of the present shareholders in the company unto and in favor of the transferee. The consideration payable by the transferee to the transferor for such assignment and transfer has been agreed to be 14.76 crores, only out of which rupees 3.60 crores shall be towards the consideration for purchase of 18% total equity shares of the company, and the balance sum of rupees 11.16 crores shall be towards 18% of the total loan amount agreed to be provided to the company under in terms of the share purchase agreement. the said consideration of 14.76 crores shall be payable by the transferee to the transferor as follows. Rupees 6.03 crores has been paid as earnest money before the execution hereof. The receipt whereof the transferor doth hereby, as also by the receipt and memo hereunder, admit and acknowledge. And then, the balance consideration, the mode is specified as to how the balance is to be paid. Now, kindly come to all these are the other stipulations in the agreement which are not relevant. Kindly see 7, 8, and 9, please, madam. At page 6, which is page 84, please, my lord. Yes. In case the transferor is ready and willing to comply with its obligations herein contained, and the transferee fails to make payment of the balance consideration within the period mentioned in these clauses, the transferor shall cause to be transferred to the transferee such reduced proportionate number of equity shares of the company on pro rata basis as be equivalent to the consideration amount paid by the transferee to the transferor hereunder. Example, in case the transferee pays 7.38 crores out of the consideration of 14.76 crores, then the transferor shall be liable to be caused to be transferred proportionate 50% of the 18% equity shares of the company to the transferee. And in such event, the transferee shall be liable to pay the proportionate amounts mentioned in clause 3.2 and 4 above, and be entitled, kindly see, my lord, and be entitled to the profits from the project to the extent of its reduced shareholding in the company, and shall be liable to observe, perform, and all take over all obligations, liabilities of the transferor under the share purchase agreement to the extent of its reduced shareholding in the company. So, my lord, if I pay part money, I get part shares. And, my lord, my share in the project, that is the new construction which is going to come up, will automatically stand reduced to that extent. Then, my lord, kindly see, in case the transferee is ready and willing to comply with its obligations herein contained, and in spite of the present shareholders completing the sale and transfer of the shareholding of the company in favor of the transferor and the confirming parties, the transferor fails to cause to be transferred the said 18% shareholding in the company in favor of the transferee, the transferee shall be entitled to sue the transferor for specific performance of the contract envisaged herein. So, if I pay my full money, he doesn't transfer, but he gets the shares, I can sue him for specific performance. Yes. Then 9. In case due to any reason, the said share purchase agreement is cancelled or terminated, the transferee shall be entitled to refund of the entire money until then paid by the transferee to the transferor immediately upon the transferor receiving the same from the present shareholders and or the company, as the case may be. So, if the parent agreement is cancelled, he doesn't get any shares, I get the full money refund immediately. That is, my lord, the clause in the agreement. Then, your lordship, kindly sees clause 11, which they will show your lordship, my lord. Any dispute arising out of or in connection with this memorandum between the transferor and the transferee, including a dispute regarding the existence or validity or termination of this memorandum or the consequences of its nullity, shall be referred to and finally be resolved by arbitration of such person or persons as may be mutually appointed by the transferor and the transferee. The arbitration shall be conducted in provisions of the Arbitration Act. Then kindly see 11. 10 is the High Court at Calcutta shall have exclusive jurisdiction. And kindly see 13, please, my lord. It is clarified that the confirming parties hereto have joined in and are executing these presents at the request of the transferor, just to confirm that they do not have objection to the transferor agreeing to assign and transfer its rights and benefits of its contract with the present shareholders under the said share purchase agreement to the transferee to the extent of 18% of total equity shareholding in the company out of the proposed allocated shares of the transferor in the shareholding of the company agreed to be purchased by the transferor under and in terms of the share purchase agreement, and that nothing contained herein shall be construed or deemed to create any privity of contract between the transferee and the confirming parties, and that until transfer of the entire shareholding in the company by the present shareholders in favor of the transferor and each of them is confirming parties hereto and or their respective nominees or nominees acceptable to each of them, nothing herein shall impair the obligations of the transferor under the said share purchase agreement, transferor shall continue to be bound by the same to the extent of its entire shareholding agreed to be purchased by the transferor in terms of the share purchase agreement in the same manner as it was prior. So they are only confirming parties, and they will ensure that I get my, my lord, 18%. Now kindly turn to the memorandum of consideration at page 87, please, my lord.
What about this arbitration clause?
Yes, this arbitration clause, my lord, is limited to disputes between me and the transferor only.
Correct.
Now I'll show you, lordship, what my suit is about. Kindly have page 87 once, please.
Okay.
This is, my lord, the consideration which I have paid, which was recorded in the agreement, 6.03 crores. My lord, 1 crore 38 lakhs was paid by me directly to defendant number 1, James Glendie and Company, your lordship finds. And my lord, the balance amount, 4 crores 53 odd lakhs, was paid by me to Jagrati Trade Services, aggregating to 6 crores 3 lakhs. At the time of signing of the agreement, or actually before signing the agreement, because all these dates are before the agreement was signed. Now, my lord, apart from these monies, I have paid another, my lord, 6 crores odd, aggregating to, my lord, 11 crores 24 lakhs. Now, all these payments which I have made, my lord, I have annexed the balance sheet. I'm sorry, my bank account statement. I'm not troubling your lordship with that because monies which I have paid are admitted. There is no dispute. Kindly come to page 90 once, please, my lord.
Yes.
Now, my lord, these are the details of payments which I have made to, my lord, James Glendie, defendant number 1, from July 2012 to March 2014, 1 crore 8 lakh rupees at page 90.
Yes.
Now, your lordship had seen the consideration was split into two components. One was loan to the company and one was to the outgoing payment as consideration to the outgoing shareholders.
Yes.
So page 90, my lord, shows the monies which I have paid directly to respondent number 1. Page 91, my lord, shows the monies which I have paid to the outgoing shareholders of the respondent number 1 who are also party to these proceedings. 1 crore 84 lakhs 47,250. Now, these monies which I have paid, my lord, are reflected in the books of James Glendie. Kindly see page 92 once, please, my lord. This is the balance sheet of respondent number 1. Now, kindly come to page 100, please, my lord. This is of some significance.
Yes. 101.
100, please, my lord.
Yes.
This is as on 31st March 2017.
Yes.
Your lordship kindly sees it is reflected as a long-term borrowing because it was to be given as loan. Now kindly see, my lord, unsecured inter-corporate loans, Tirupati Vancom Private Limited. That is the plaintiff before your lordship, my lord.
Yes.
Your lordship has that 4 crores 73 lakhs 43,000. So, my lord, here what I'm trying to show your lordship here is the agreement between me and R2 and the confirming party specifically said I am assigned and transferred all the rights under the share purchase agreement.
Correct.
So the agreement is assigned to me to the extent of 18%. That is why in its balance sheet, my lord, respondent number 1 recognizes me separately as a party.
Correct.
I am not through Jagrati. The case with the respondent number 1 is now running, and in the other plaint which they filed is that these payments which they received from me were on account of Jagrati, which is incorrect. Because Jagrati has already assigned. The agreement says assigned and transferred.
Yes.
And they accept that position. And that is why, my lord, they recognize me as having provided the intercorporate loan and not Jagrati.
Correct.
Now, my lord, kindly says, so 4 crores 73 lakhs admitted here.
So what is the second column? 2 crore 71 lakh?
My lord, this was for the previous year. I'm sorry, my lord. That was that was the previous year's figure. This is the current year's figure. That was as on 31st March. I'll give a better copy, my lord. It's just they've printed it like that. That's why it's not showing.
Yeah, that's
the column on the right is the previous year's figure. Column on the left is the current year's figure. So as on 31st March 2017, my lord, so much money was admittedly paid.
Yes.
Now, my lord, the construction, the entire the agreement was, my lord, the purpose of the agreement was for construction of the project. During this period, these respondents brought in a developer. Earlier, these respondent shareholders were to contribute funds and raise the building. So they would get the full 100% share of the constructed area. Now, during the pendency of this agreement, they brought in a builder by the name of Siddha Developers, who, my lord, would now carry out the construction. Therefore, what happens is, my lord, Siddha pays premium to respondent number 1. We have to pay a lesser amount to respondent number 1. So I was not required to pay the full monies. I was required only to pay the lesser amount money. And there was no claim from me for the balance amount ever. Matters were going smoothly. There was no problem. The building was being constructed. 2023, the building got a partial completion certificate. Not even full completion, partial completion. At all times, I was told by the respondents that once the building gets constructed, we lease out the areas. Whatever profit comes, you will get in your share 18%. That is where matters stood. Now, my lord, in July 2024, that is last year, my lord, I got a notice of mediation. Notice of mediation institute of a proceedings to be instituted by James Glendye, that is the company.
So 2011 you have entered into the agreement.
2000, yes, my lord. 2012 I entered into the agreement.
12 you entered into agreement. Till
Yes.
2017 you have paid the amount.
2017, more or less, the monies were fully paid.
That's right, completed.
And then construction had commenced. Construction had
till the completion of the construction, you will not get any share or any profit on that.
No, my lord, because
Only the completion.
once the not only after completion of construction, my lord, the property has to be sublet. This is a commercial building, so it has to be sublet. Deeds of sublease will happen. Then, as a shareholder, I'll get my whatever percentage of profit, which the parties also recognize. You will get your share from the project. The reimbursement my income will come from the project once it is dealt with. So 2023, the project got a completion partial completion certificate.
2024.
2023.
Yes.
Now, my lord, in 2024, 15th of July, my lord, your lordship will kindly see at page 105, I get a notice of pre-litigation mediation at the instance of the defendant number 1.
Yes.
Kindly see, my lord, 15 July. At page 105.
Yes.
I get a notice from defendant number 1 that it intends to sue Jagrati and me. Kindly see now, applicant is James Glendye. Towards the bottom of the page on the left hand side, please, my lord. Your lordship will find applicant.
Yes.
Applicant is James Glendye and its outgoing shareholders Deepak Bhargava, Rajni Bhargava, who also parties to this suit. Opposite parties, my lord, against whom the mediation is started, is respondent number 2. Respondent number 3. 3 is another company of the respondent number 2. Then me, your lordship will find Tirupati Vancom. Then Orbit Towers.
Yes. Yes.
This was the pre-litigation mediation. Now, my lord, when this pre-litigation mediation notice was received, I was not aware of any disputes between the parties. So I instructed my lawyers to make inquiries. From which now, my lord, I come across page 108. Kindly have page 108. This notice came in July. I instruct my lawyers to check what is happening in court because I am not aware of any of this. Now, kindly see page 108.
Yes.
This is an order made by this honorable court, my lord, in 2 section 34 applications.
Yes.
One filed by, my lord, the shareholders of James against Jagrati, which your lordship will find at the top,
yes.
AP 388. The other filed by Jagrati against the shareholders.
Yes.
And this judgment was delivered on 4th of September 2024.
Yes.
Now, my lord, from here I find that there is an arbitration between these parties.
You are not the party here.
I am not party here.
Okay.
And the arbitration, now kindly see paragraph 2 at page 109. The matter emanates.
Yes.
The matter emanates out of a share purchase agreement dated 24th March 2011 entered into between the parties. The claimant, that is my lord Jagrati, sought specific performance of the contract along with damages for breach of contract, whereas the respondents in their counterclaims sought specific performance, now kindly see, of their version of the same agreement. Both the seller and the buyer both sought specific. Now, but what the arbitrator ultimately holds, kindly see paragraph 3. The claimant's prayer for specific performance was refused by the learned arbitrator on the ground that the copy of the contract filed by it is incorrect. So, Jagrati, my lord, filed a fraudulent document, it appears, is incorrect, suspicious, and differs from the original, as well as the entire payment obligation of 36% of the shares of rupees 82 crores was not discharged by the claimant by payment of rupees 19.92 crores. So the arbitrator found his agreement was spurious and he's not paid the money also. Then damages were also refused and they were required to give back the money. So this is where, my lord, I come to learn of this arbitration. Now, my lord, kindly bear in mind, under the MOU, the rights under this agreement have already been assigned to me. James is aware of this. He gets money from me. He records me as a creditor by payment of loan. The other shareholders have also got monies to me. They don't impede me in this arbitration.
Correct.
I am not made party to this arbitration, although my rights are affected by this arbitration. Because if he doesn't get 36%, your lordship sees under the agreement, whatever payments I have made, I am entitled to shares. Everybody is aware that I am making payment, I am entitled to shares, whether Jagriti pays or doesn't pay.
But in the agreement, you are not the party. 24th March, you are not.
Yes, agreement I am not party, but I am being assigned.
Assigned with the subsequent of
Yes,
memorandum.
assigned by the subsequent and recognized. Recognized by my lord James and its shareholders. That is why I showed your lordship the balance sheet. Loan has come from me, not from him.
Correct.
So, my lord, the agreement is assigned to me, yet I am not made party to the arbitration.
Yes.
And I am vitally interested, my lord, in the outcome of this arbitration because it determines my 18% shares also.
Yes.
But neither of these defendants, my lord, make me party to the arbitration.
Yes.
Now, my lord, when I come to learn of this award, I immediately, my lord, write to the parties. Now, kindly see the steps I take. Kindly see page 131. I write to, my lord, Jagriti, Orbit and Damani, who are the incoming shareholders.
So what has happened in the 34?
My lord, 34 dismissed. Both 34s dismissed, it appears. 37 also dismissed. Now pending before the Supreme Court, appeal admitted. One of both parties filed 37, if I'm not wrong. My learned friend will correct me. And then James ultimately went to the Supreme Court against dismissal of 37. Jagriti did not. Jagriti accepted the result of the arbitration ultimately. The result of the arbitration, my lord, was that Jagriti will get refund of the entire money which has come, along with interest.
Correct.
So, my lord, the monies came deposited in court. Now, this includes, my lord, the monies which I have paid. Because before the arbitrator, since I was not impleaded, the entire payment which was received from me was treated as having been made by Jagriti. So 19 crores odd Jagriti had paid, out of which 11 crores was paid by me. Admittedly, it's an admitted position.
So some amount has been released.
19, now, my lord, the entire money came to court as a condition under 36(2).
Correct.
James was directed to put in the money. This money which James put in along, so James was also contesting, it lost till the division bench.
Correct.
Jagriti filed an EC. In the Supreme Court, James said that I am only disputing now the quantum of interest which is directed to be payable. I will refund the money. So the Supreme Court permitted Jagriti that you take back the principal. So that is how, my lord, after I filed the suit, Jagriti took out 19 crores. Where admittedly out of these 19 crores,
What was the amount pending there? No.
here only about 8 crores. Out of 26 crores, 19 he has taken away.
So
And
your
out,
claim is total?
beg your pardon, my lord?
What is the total claim?
My claim, my lord, is in, I'll show you, lordship, my lord. Kindly see the plaint once, please. The paragraphs of the plaint, I've set out the reliefs claimed in the plaint.
26.
Yes. 26 is, my lord, refund on
Plus
account
interest.
plus interest from 12% till the date of refund is 26.92 crores. Money is lying in court is not sufficient because he has already taken away, my lord, 19 crores, out of which 11 crores is paid by me. The 19 crores which he paid to, which James said I've received, includes 11 crores paid by me. So he has taken away this money. The rest is, my lord, my claim for damages. Because I was entitled to 18% shares. I did not get the shares. So I am entitled to profit. Whatever was the profit from the project, I will get that. That is my claim for damages. Now, your lordship kindly comes, your lordship has a matter.
नहीं, 11:30 है. Okay, come tomorrow.
Tomorrow, please. Let it retain its position in the list, my lord.
No, tomorrow दूसरा मैटर है ना? क्या है? 25. ये वाला. So come on 25.
Please.
But only thing is, I had my section 8, which because of
Already told, let Mr. Thakkar argue the matter and he want to give the reply to the two. Otherwise, you can argue the matter on both the application. I will
If
discuss.
he is there on the next day, he can.
Yes, I can start my section 8. Yes.
both application together, so the matter can be disposed.
Well, there is just one
On
thing.
23rd, Malad is a Saturday. Malad, which date Malad is?
25th. 25th.
25th. Very well.
Counsel for the plaintiff has argued the matter in connection with GA1 of 2025, but due to paucity of time, hearing could not be completed. Let the matter appear on 25th.
Malad, along with my GA, so that Malad, if Mr. Thakkar permits, I can start my other GA as well, because perhaps Malad, if it's
Yes, he can do his GA2. I have no difficulty. He was
very
not.
well.
That's why we started.
Filed by
Very well. GA2.
Well, there's one order which your lordship had been pleased to make on 23rd July, extending the time to complete to carry out the defect removals in the plaint. The plaint was in court, my lord, because your lordship was considering GA3. Kindly extend the time by 2 weeks, my lord.
By an order dated 23rd of July 2025, this court granted leave to the plaintiff to rectify the defect within 2 weeks, and also to file fresh affidavit and verification within a week thereafter. It is submitted that this the plaint along with the connected application is pending for hearing of the interlocutory application, and as such the plaintiff was not able to rectify the defects and re-verify and affirmation of the affidavit and reaffirmation of the affidavit, and as such he prays for extension of time. In view of the submission made by the counsel for the plaintiff, time to comply with the order dated 23rd of July 2025 is extended. How it can be so? By it can it be sent and you?
Yes, please, my lord. Now the
within a period of further period of 2 weeks from date.
Well, then may the affidavit in reply be kept.
Affidavit in reply filed by the plaintiff in connection with GA1.
25th is your lordship pleased to fix a time, or it will appear in its position in the list?
Position.
Grateful, Malad.
Only one thing, Lord, a copy of the plaint has been given to one of the defendants. If it can be also made over to us, Lord, for the defendant.
You are appearing for whom?
Lord, defendant number 1, James Glendie, the company in question.
Let
the claim be corrected, everything will come.
Our
With the
correct
return.
when we change.
My lord, if your lordship may just consider, my lord, items 16, 17, 18, 19, the next 4 matters. My lord, opposition has been given to us only just 4 days ago. My lord, kindly adjourn it for our reply, my lord. Both sides are there, my lord.
Opposition affidavit in opposition was served on them
15, 16?
16, 17, 18, 19, my lord.
16, 17, 18, 19.
Lordship, may I file my opposition, your lordship?
Counsel, you are for the?
I'm for the plaintiff, your lordship.
Counsel for the plaintiff filed affidavit in opposition.
In GA5.
In GA5. In all cases?
In GA5. In GA5.
GA5. After serving the copy to learned counsel for the defendant. Solicitor counsel for the defendant prays for time to file reply.
Reply, my lord.
Let the reply be filed within a week.
Within a week.
Within a week. Release the matter on 9th September.
Can your lordship make it 2 weeks? My friend
Within 2
requesting.
weeks.
Great.
Lordship.
Yes.
Earlier it was 1 week only, your lordship.
Yes, next.
We are coming up, Miller, with this matter, Miller, after quite a long time.
बोला है तो मैडम को देख दरवाजे में लगाएगा वो उसमें भी दे दो अच्छा ठीक लगा दो उसमें नहीं दी क्या yes
We are coming up with this matter, Miller, after a quite long time. Miller, this is Miller with that sale matter.
Plate.
Yes, Miller.
Get pass.
Get pass. Miller, Miller, I'll just, Miller, it's quite a long time, Miller, in the meantime, Miller. Twice, Miller, they had taken time, so, Miller, could not happen. Miller, I am the, Miller, logistic provider, transporter. Miller, I do my regular bread and butter is, Miller, with sale. Miller, sale had, Miller, restrict, Miller, basically, Miller, cotton, Miller, of my truck milad while entering milad the plant milad at milad Bokaro. They said that I have tampered with the milad number plate. Now milad I have changed the number plate. They got hold of the driver. They caught hold milad of the driver. The milad driver is on bail. Now milad under the milad the scheme of milad cancellation. Milad they had cancelled my with all business relationship with me for 3 years. Initially it was for 6 months. Immediately 6 months was getting over. Then three years imposed ban was imposed. Now milad I had called upon them for a seeking milad right of milad natural justice milad a hearing which is milad contemplated under the scheme. Now milad while moving the application before lordship on the first day, one liner order was passed that you given hearing ban to continue for 3 years. I come up milad with a milad writ petition before with a suit milad before your lordship. My lord, going through milad the entire milad application, milad had come down to milad 3 findings that a quasi judicial body is under an obligation to give reasons. That was absent. Number 1. Number 2, milad it was on contest. Point was taken by my learned friend that presence of arbitration clause. My lord had milad considered that and said that milad no, that's not an bar milad to proceed to pass an interim order. And number 3, milad civil court. So jurisdiction, Bokaro civil court. Milad prima facie, my lord had come milad to a conclusion that milad these 3 are not at all a bar to pass an order restraining them milad from taking any coercive steps milad in terms of the said banning order. Now milad additionally my lord had also passed an order to intimate milad all the stakeholders and milad the stakeholders at large in the open market that my lord had passed an order. There is a subsisting order of injunction on them. That has been done. Now milad well coming back milad they filed milad a GA2 seeking my lord's leave to file written statement. I have relied on 2 of my lord's order judgments milad where milad after 120 days even if filing milad application filed not milad they have to take leave that they have not obtained. So milad written statement part is over, their application was dismissed. Now milad third application there are now 2 subsisting application before lordship, that is GA1 that is my injunction application and GA3 milad. GA3 is milad basically praying for 2 reliefs, rejection of my plaint and or alternatively section 8 to send back to arbitration. Now milad the contention of milad I had tried to milad canvass before your lordship that the arbitration clause that is clause 49. My lord recollect there are 2 clauses 49 and 50. 50 the jurisdiction clause, 49 is the arbitration clause. My lord had gone through milad meticulously milad through the entire milad records milad and when milad we are arguing milad I have tried to canvass before your lordship was that 49 consists of an milad a bracket that few matters
which matters are required
are accepted. Now milad 49 cannot be read in isolation. My lord will have to read with clause 44 of the same agreement. Now milad I have relied on milad of my lord's judgment Deson milad passed by lordship that reference of milad an arbitration clause has to be there into the main agreement. Yes. Now milad my other clause is that the cancellation banning procedure which milad bears no reference to this arbitration, no jurisdiction, plain and simple. Milad I have relied on milad catena of judgments milad where to show before your lordship that if an accepted matter is even if sent to the arbitration that is not arbitrable. I have relied on Hirsch construction of 2014-19 SCC. That's my lord. Now milad I have also relied on few judgments which milad says that your referral court should be specific. Milad I have relied on milad three judgments of by Honorable Justice Sanjeev Banerjee, 1 judgment of Honorable Justice Shahidullah Munshi of our court, all are of our court. Milad if the referral court is not properly mentioned, it cannot be referred. Now, my lord, in clause 50, my lord will find it is written quote unquote civil court. Now, my lord, this is my lord, they have relied on a my lord, basically my lord, the clauses were framed in 2021, that 2022, so admitted case. So, my lord, 2022 throughout the country, every district and every high court had a commercial division. My endeavor was before your lordship was that the draftsman who had drafted the scheme or drafted the frame the policies had the knowledge and ought to have the knowledge that this matter under the sun cannot go before a civil court. This had to go before any district before a commercial court. I would have understood this is drafted or promulgated prior to 2015. In many cases, in railway matters, we also follow 2001-2002 GCC. Now, this case, it's a 2022 document. So, even if my lord refers me, follows the jurisdiction clause, refers me to civil court at Bokaro, Bokaro has also a commercial division court. Civil court at Bokaro, cannot receive my petition.
Why commercial court is not there?
Commercial court, that I tried to I relied on section 3, 6 and 10 of the commercial courts that civil court and commercial courts are defined. If would not have been defined, there would have would have what should I say, if the law is unambiguous, there is no scope for court to give a external aid or to interpret the law. The draftsman who had drafted this policy, I take it that he ought to have been aware that this matter could not have gone to any civil court. And civil court are not commercial courts. Commercial courts are defined under the Act, and a commercial court and civil court are a totally different stream.
When the agreement was entered?
2022, they have 2020. Those are admitted. Nobody is denying on that. They are my LOA is of 2023, 2024. They rely on a 2022 document that these are binding. Now, I have relied on catena of judgment of this honorable court. They are one of the judgments. It was written that honorable court at Orissa. In Justice Banerjee, one of the judgments that the honorable court at Orissa. That Justice Banerjee was of the view that there is no court of honorable court at Orissa. There has to be a specific honorable high court. Now, it was also written that honorable high court at Kotak. Justice Banerjee was of the view that there is no court honorable high court at Kotak. So, the referral court has to be specific. Now, I have also relied on catena of judgments that they have themselves alleged fraud. That my personnel had committed fraud, and in their letter at page 45 of GA1, I have annexed. They have said you have committed fraud on us. So, if fraud is the subject matter, I have relied on a recent Delhi High Court judgment of to 11th March 2025 unreported. I have given a copy to my learned friend also. It has considered all the catena of judgments, Ayappa, Sami and all those things, that fraud of a grave nature which they are alleging is not arbitrary. So they cannot now take or shift their stand. If to show that the fraud has been committed by me, either I or they have to call the BSF Jawans who had caught hold of my driver, my truck, the security guards, all the portfolios have to be the entire ministry have to be made aware of it. Now, under such scenario, I have shown before your lordship that under such circumstances, court is the only way out, and arbitration is not a proper remedy. Now, Millet, if Millet kindly takes Millet their application GA21s, one more thing, Millet, I have also relied on Millet section 8(2) of the Arbitration Act. Millet, it's been settled by Supreme Court also, Millet 2008 2SCC 602, that original agreement has to be annexed. Anybody who is filing section 8. So naturally, Millet, they have not annexed the original. These are all technical points. Millet, this last one.
But you are not denying that.
Arbitration clause. Yes, I'm coming to that. But yesterday night I was going through. Now, I will kindly take Millet GA3.
Yes.
Kindly comes to page 76. Kindly see Millet, my lord Master Mark Millet, clause 44. Illegal unauthorized act and adverse report. If any staff of the contractor is caught in a theft case or in unauthorized movement of materials or in any activity which is punishable under law or not authorized by the plant, the contractor will bear full responsibility for the loss or other consequence which may result to the plant due to such illegal unauthorized acts. Beside the action to terminate the contract by the plant, the contractor shall also be liable for any act leading in the banning of the business with them. So, Millet, these two Millet have been done by them under the banning policy. Now, Millet kindly comes to Millet 49. All questions, claims, disputes, or differences of any kind whatsoever arising out of or in connection with or concerning this contract at any time, whether before or after the determination of this contract, other than questions, claims, disputes, or differences for the decision of which specific provision have been made in the foregoing clauses of this condition, herein are referred to as the accepted matters, and decision on which accepted matters according to the said specific provision shall be final and binding on the parties to this contract and shall not be reopened if attempted to reopen on the ground of any. Now, may I pause here for a moment? There are 4 grounds which are being made: informality, omission, delay, or error. If these 4 grounds I am reopening it, then in the proceeding or any other group whatsoever shall we refer the parties for the decision by the sole arbitrator to be appointed as hereinafter mentioned. So there are 4 grounds which are mentioned: informality, omission, delay, error. Apart from this, are not arbitrable. Now, I was consulted the legal dictionary. I'll give a copy to my learned friend.
Which black law?
Is purchased by me during my college. When I was new into the profession. It's usually not being used. I was told when I immediately came by Mr. Mithro that you should, I was with him, you should buy a dictionary, legal dictionary. So at that point of time, it was purchased. Now, kindly see delay. I have ticked kindly for first page after the preface. Delay. I have penned my for Lordship's assistance. To hinder, detain, keep back, or return to arrest progress. Now, my case does not fall under delay. I have not accused of them or anything of delay.
Telling on that.
So neither their case, not my case. I'll coming to that. Now, let's kindly turn the page. Error. Error. Next page. Right hand side, top, error. I have marked a mistake of law or of fact in the judgment of a court, mistake of any kind. A mistake in judgment, then it has. So this is also neither their case, not my case. Now, Millet kindly turns the page, informality. Right hand side, middle. Absence of or non-observance of due or prescribed form. This is also not their case, not my case, that you have not followed a form. Now, omission, kindly turns the page, denotes as well a series of omission as a single omission, omission with reference to the performance of a duty involve the idea of conscience or willful omission. Act includes omission. The expression omission does not connote any obligation. Omission is the colorless word which merely refers to the not doing of something, and if the assessee in fact does not make a return, then so these are the 4 grounds. If on these 4 grounds I challenge their act, that is arbitrable. Now, I will now request our Lordship to come back to GA1 once. While reading this, I have come across one theory, useless formality theory, which is akin with informality. I brought those catena of judgments, So, I will come back to that. Kindly takes GA1 once.
So that's why sometimes we or higher authority, higher court pass an order.
No point hearing them. So useless. So that has been saddled by Supreme Court.
Yes, but it's still going.
Supreme Court has said in all the 3 judgments I have carried from 1996, 2005, 2009, saying that this cannot be followed.
Because see, if suppose district judiciary's order is before us, and if I find or the court find, yes, it has to be here, heard it on merit, and we are not staying, we carrying that, yes, you can proceed with and we hearing. So what is the meaning on that?
But Supreme Court has I'll request your Lordship to kindly once take GA1 to show that what was my case. Kindly see the first suspension, page 45.
Page 45.
45.
Yes.
Kindly see, this is there later. This is the first lot of suspension.
Yes, you pointed. See,
since the
already argued, pointed out, and this court has taken note of it. Yes.
So, I will not repeat on this. Only to show that what my case was. That allegation of fraud, and you have not given me hearing.
Correct.
For a moment,
fraud on the basis of which you have initiated,
and they have themselves said serious nature fraud.
Correct. You have initiated the proceedings and passed the order without giving an opportunity of hearing.
And one liner order passed. Kindly have a look, to the banning order, page 50.
50.
Yes.
Yes.
Page 50. It has been decided to ban future dealing. That's all. Nothing more, nothing less.
Yes.
Now, kindly turns to page 52. This is the guidelines for banning.
Yes.
These guidelines for banning does not make any reference to arbitration.
That you are also argued.
Neither any jurisdiction clause.
Correct.
So, I will not repeat myself on this. Very well, Now, I will try to canvass before your Lordship that there are 4 heads. My case are beyond these 4 heads. If my case is beyond these 4 heads, I come under the accepted clause. Now, what I was referring to, though I am carrying while going through informality, I came across this. I thought that this 1999 6 SCC 237. Copy আছে। Kindly comes to paragraph 15. Well, main is 22, but 15 is also necessary. It is true
Yes.
it is true that whenever there is a clear violation of the principles of natural justice, the courts can be approached for declaration that the order is void or for setting aside the same. Here, the parties have approached this court because the orders of the department were consequential to the orders of this court. The question, however, is whether the court is exercise of its discretion under Article 32 of 226 can refuse to exercise discretion on the facts or grounds that is prejudice is established. On the facts on this case, Miller, then Miller, I not bother Miller, 16 Miller can mark kindly comes to 22. Here, Miller, that theory Miller has been deprecated. Before we go into the final aspects of this contention, we would like to state that cases relating to breach of natural justice do also occur where all facts are not admitted or are not all beyond dispute. In the context of those cases, there is considerable case law and literature as to whether relief can be refused even if the court thinks that the case of the applicant is not of one real substance, or that there is no substantial possibility of his success, or that the result will not be different, even if natural justice is followed. Well, all the judgments are referred. Now, Millard kindly turns the page after Millard and knows John versus Reese in the in the middle Millard.
Yes.
Stating that there are always open and shut cases and no absolute rule of proof of prejudice can be laid down. Merits are not for the court but for the authority to consider. Akna J has said that the useless formality theory is a dangerous one. And however inconvenient, natural justice must be followed. His Lordship observed that the convenience and justice are often not on speaking terms. More recently, Lord Birmingham and had deprecated the useless formality theory. Then Millard, all the judgments are again referred. Then Millard, judgments are referred, Millard, and Millard, I will not Millard bother your Lordship. So Millard, ultimately Millard, this useless formality theory was deprecated. Now Millard, there are other judgments of Millard, same line. I am not Millard wasting your Lordship's time on this. Millard, this is 2005 6 SCC 321. Kindly mark the paragraph, Millard. 7 to 11. 7 to 11, 14 to 17.
Yes.
I mean, the next judgment, and these are on same, so I'm not unnecessary.
Okay.
2009, 12 SCC, page 40. This judgment was passed on Millard, this MC Mehta case, where Millard again, the informality theory was Millard deputy. The entire judgment Millard has copy pasted Millard MC Mehta. So Millard, while going through Millard, the only paragraph written by the Millard that honorable court is at paragraph 4. Last paragraph. After Millard setting out entire MC Mehta judgment.
Yes.
So Millard, these are the 3 judgments on this proposition. Now Millard, coming back to the case in hand, that my case is very simple. This 4 heads doesn't cover me. And if this 4 head doesn't cover me, I am within the accepted clause. Now, Millard, I'll just sum up with this, Millard, then I'll go to their judgments. Coming back to the civil court, Millard, my answer is the same. That first of all, this Millard has held in 30th July order 2024 that this court has the jurisdiction. All parties are within. 7 except Millard, the Bokaro Millard and Millard, I have shown Millard, I have received the banning order within. The online process of giving hearing, though Millard online, there was some technical glitch on that day I pleaded, had taken place at 50 JL Nehru Road, that is also within. So Millard, the entire process is within. So Millard has held in Millard's order that Millard has the jurisdiction, this court has the jurisdiction. Whether this can be Millard recalled or Millard finally will decide that this court doesn't have. Millard had already stated in Millard's order that this will be dealt with Millard in trial. So if that is so, Millard at this stage, Millard, when there are substantial glimpse of dispute, whether the arbitration it can be referred to or not, Millard, my respectful submission is before your lordship that Millard, this should continue before your lordship's court. Now, Millard, coming back to their judgments, লাগানো 89 no? আচ্ছা 26 July? না just এগোতে লাগিয়েছি 30th July order, just for a moment, Millard. Millard, page 5 of Millard 30th July order. Page 5, paragraph 3, third paragraph, no paragraph number is given, third paragraph.
Yes.
Learned counsel for the plaintiffs has also submitted that clause 49 and clause 50 of the NIT are contrary to each other and are mutually destructive. That's also my case. As per clause 49, the NIT, there is an arbitration clause. And in clause 50, there is a clause of civil court. And as such, both the clauses are destructive in nature. And as such, the court is of prima facie view that the objection raised by the counsel or defendant is not sustainable. Clause 10 of the guidelines provides for appeal, but the plaintiffs have not only challenged the order of banning, but the plaintiffs have also prayed for decree of the amount of due and payable to the plaintiffs by the defendants, as well as several other prayers and such. This court is of the view that the claim made by the plaintiffs with regard to the amount due and payable to the plaintiffs and other reliefs as prayed for by the plaintiffs cannot be decided by the appellate authority, and as such, this court is of the view that there is no bar to file the present suit. Now, this court has to see whether the plaintiffs are entitled to get in interim lease as prayed for. The defendants have passed an order of 20th March 2024, wherein it has been decided to ban the future dealing with the plaintiff company for a period of 20 such and such. From the face of the record, it is found that the banning order does not provide any reason. Though in the order it is mentioned that the reasons are annexed here too, but no reason has been annexed with the said order. Prior to the order of banning on 28th March 2024, on 8th September 2023, the defendant had suspended the services of the plaintiffs with effect from 8th September 2023 for a period of 6 months. And immediately on completion of the period of suspension, the defendant had passed the impugned order. Considering both the order, this finds that the plaintiffs have suffered double jeopardy. And also banning the order does not contain any reason as to why the banning order has been passed for the period of 3 years. This court finds that the plaintiffs have challenged the banning order and thus it is to be decided during trial. And if that's this stage, the banning order is not stayed, the plaintiff will suffer irreparable loss and injury. The court finds have made out a prima facie. So Millard left it open for the trial to be decided. Let the trial happen.
Yes.
Now Millard, coming back to their judgments, And Millard, for the risk of repetition, I just Millard, there kindly comes to once Millard, sorry Millard, page 72 of GA3. So sorry.
Yes. 72. Yes.
That guidelines that they are referring to. Kindly note at the top, NIT terms and conditions with effect from 5/9/2022, LTE cases.
Limited tender.
Mine is STA.
Yes, that I already taken.
Mine is STA. So, my letter pointed out to them that what is the difference between LT and STA and whether there are any guidelines of separately STA. So, they are to show on this. Now, coming back to the judgments, my learned senior had shown 2007 USLR. It's Philly Shipping Co Limited. দেখুন Philly Shipping এই যে এরকম দেখতে।
Yes.
Fine. Let kindly turns to paragraph 2. The case has been argued. Paragraph 2.
Yes.
The case has been argued on the basis that there are two issues. First, whether as a matter of construction the arbitration clause is apt to cover the question of whether the contract was procured by bribery. And secondly, whether it is possible for a party to be bound by submissions to agreement when he alleges that but for bribery he would never have entered into the contract containing the arbitration clause. It seems to me, however, that for the reasons I shall explain, these questions are very closely connected. So, there is a clear distinction with my case. In this case, the contention of the respondents were that they have not signed the agreement. It was being signed by somebody else who had no authority. No, so, their contention was that the agreement itself is a product of bribery. But my case is different. My case is that it is a serious nature of fraud that has been admitted by them also at page 45 of GA1. So, there is a clear distinction, and I'll like to distinguish on this feature that the case in hand before a lordship and the judge, the facts and circumstances on which this judgment was passed was different. Now, it kindly comes to paragraph 13, 1-3. 13 at page 1725. 13. In my opinion, the construction of an arbitration clause should start from the assumption that parties as rational businessmen are likely to have intended any dispute arising out of relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be constructed in accordance with this presumption unless the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. I am on this. In my case, clause 49 read with clause 44 makes it an accepted clause.
Yes.
They are, I rely on this paragraph that this honorable court has also taken view that if it is culled out from the original agreement and made non-arbitrable, that cannot go into arbitration.
Yes.
Now, kindly turns to paragraph 33 at page 1730. 33.
Yes.
The owner's case is that as there was no real consent to the charter parties because they were induced by bribery, there was no real consent to the arbitration clause. They submit that a line does not have to be drawn between matters which might impeach the arbitration clause and those which affect the main contract. Which is needed is an analysis of whether the matters that affect the main contract are also matters which affect the validity of the arbitration clause. As the respondent charterers point out that this is a causation agreement, the owners say that no substantive distinction can be drawn between various situations where the complaint is made that there was no real consent to the transaction. It would be contrary to the policy of the law, which is to deter bribery, that acts of the person who is alleged to have been bribed should deprive the innocent party of the access to the court for determination of the issue whether the contract was induced by bribery. The Miller 34, Miller kindly leave 4 lines from the top. Kindly read Miller. Everything depends on their contract, and if there was no contract to go to arbitration at all, an arbitrator's award can have no validity. So where the arbitration agreement is set out in the same document as the main contract, the issue whether there was an agreement at all may indeed affect all parts of it. Issues as to whether the entire agreement was procured by the impersonation or by forgery, for example, are unlikely to be severable from the arbitration clause. But my case is totally different. Millard, in the main agreement, there is no reference to arbitration clause, which Millard had also found by this honorable court also. That Millard, in the main agreement, there has to be a reference of the arbitration clause. Millard, again, Millard, my lord, Descon judgment, Millard is there. Now, Millard, paragraph 35. Again, Millard, 4th line, the contractor induced by bribery.
Yes.
So, Millard, this is factually and Millard in all probability, Millard, on different facts and circumstances. And Millard, what I have read over, Millard, this judgment, Millard, in Indian law is contrary to Sukanya. Because Sukanya says that Millard, there cannot be dissection of Millard causes of action. And section 8 under such scenario is liable to be dismissed. Millard, kindly makes a note, Millard, this is contrary to the Indian law, Millard, which has been Millard laid down in Sukanya. Now, Millard, they have relied on 2024 SCC Online Calcutta 6369. 2004 SCC Online Calcutta 6369.
2024.
Yes, Millard, Justice Shobboshachi Bhattacharya judge.
Yes. You already given reply.
Yes.
Paragraph 32.
Millard, it's in my favor because Millard, in this Millard, the court has found that Millard, if two mutually clauses are there, it cannot be in limbo. So court there, the agreement should come to a definite finding. So Millard, in my case also, civil suit, civil court and arbitration, Millard, they cannot lie and go together. So Millard, paragraph 24, 26, Millard, 28, Millard, kindly see 28 once. 28. Kindly see 26. Well, I'm so sorry. 26.
Yes, you have taken. I have taken.
Yes,
already asked you.
Forum select last line.
Yes.
The forum selection clause has to be read along with the arbitration clause, since it does not supplant but supplements the arbitration clause and qualifies the same, providing merely the forum for redressal of the dispute which are indicated there. Hence, there must be an identity in the ambit of dispute covered by the arbitration clause and the forum selection clause. Otherwise, it would be absurd and unworkable. Millard, my contention is that.
Okay.
Millard, the next judgment is Millard of Justice Shampa Sarkar, Millard 2025 SCC Online Calcutta 1646. Millard, this is perhaps with regard to section 12 subsection 5 of arbitration clause. that a person who had a personal interest, my lord, in the dispute in result cannot appoint. So, my lord, I had taken a point that, my lord, clause 49
Yes.
gives the power to general manager, my lord, Bokaro Steel Plant to appoint. So, my lord, that clause is, my lord, inoperative because of the, my lord, recent law, subsequent law.
Yes.
Now, my lord, kindly see, my lord, in fact, my lord, it has dealt with, my lord, TRF, Parkins, my lord, paragraph 21, my lord, it has again dealt with, my lord, TRF. Now, my lord, kindly see paragraph 14. There is no, kindly see paragraph 14. There is no quarrel to this proposition. Because, my lord, 14C, kindly see, part of 169, a clause that allows one party to unilaterally appoint a sole arbitrator gives rise to justifiable doubts as to the independence and impartiality of the arbitrator. Further, such a unilateral clause is exclusive and hinders equal participation of the other party in the appointment process of arbitrators. I am also saying that.
Yes.
Now, my lord, if the principle of express waiver contained under the provision of section 12.5 also applies to situation where the parties seek to waive the allegation of bias against an arbitrator appointed unilaterally by one of the parties. After the disputes have arisen, the parties can determine whether there is a necessity to waive the nemo judex rule. Milad, I really, Milad, there is any, Milad, I also say, Milad, that there, if general manager is given the power to appoint, Milad, he will be biased person. It's contrary to, Milad, those Katinov judgments. Even I relied on, Milad, TRF and Parkins, your lordship. Now, Milad, 2018, SCC Online Delhi 9650.
Adjudicator.
Yes, 9650. Milad, kindly takes, Milad, page 7. Page 7. In Supreme Court in Eraj Boman Khavar versus Tukaram Sridhar Bhatt held to attract that the doctrine of res judicata, it must be manifest that there has been conscious adjudication of an issue. A plea of res judicata cannot be taken aid of unless there is an expression of an opinion on the merits. It is well settled in law that the principle of res judicata is applicable between two stages of the same litigation, but the question or issue involved must have been decided at the earlier stage of the same litigation. But I have also said the same thing. I have relied on 2022 SCC Online Supreme Court that Millard had come to a finding and Millard led the parties to trial to be decided. They are agitating the same issues before a lordship. When Mr. Basu was there, when on contest, Millard had decided the same issues of arbitration and all those things. Millard, then Millard, he has also relied on 2013 15 SCC 655 that Eraj Boman covered.
Yes. Same adjudicator.
Same.
Yes.
Same. That's it. Rest I'll give a notes, Miller, after they complete, Miller, on the next.
Yes.
I'll put it on notes.
Can you give us a date, any date after 1 week to reply to the judge?
Counsel for the plaintiff has concluded his argument. Counsel for the defendant prays for time to give reply. Accordingly, case is adjourned. Let the matter appear. September.
4th September. Miller, interim order copy of the assets. Interim order manually extended still today, Miller.
Interim order is extended till 10th September 2025 or until further order, whichever is Sunday.
Great. Whenever my learned friend was making submissions.
Yes.
What if the thought issue which was there? There was an agreement under 56, then 97 came into picture. It cannot govern the field because threshold limit is much higher. So the agreement, unregistered agreement, it comes to 106. Now, what I want to demonstrate before this court is, lease is an agreement. Lease is an agreement. Therefore, the terms and the condition which was there previously and in cross-examination, he accepted, the witness accepted that yes, we have governed by these terms and conditions. So that terms and condition will come into play. Up till this, I have demonstrated my evidence, I have scrutinized my evidence and I have placed before. Now, Lordship, what I want to say is, if that comes into play, then whether the termination clause by 15 days notice will stand or it will be treated as a lease which is 11th month lease with the clauses of that agreement. If we simpliciter take the proposition of law that 106 unregistered document, so it is month by month. So moment we say that it is an unregistered instrument month by month, then Lordship, there is a notice, I have been terminated, I do not have anything to say. But my endeavor is to show that when it is unregistered, then agreement parties have accepted the terms, even on the doc he has accepted the terms, then it will be a 11th month discrete agreement. Now for that, TPI. For that, if your Lordship kindly takes up first, we will see the definition of the lease.
Yes.
Lordship, the lease of a immovable property is a transfer of a right to enjoy made for a certain time.
Yes.
I pause here for. So the essence of a lease is a contract and the time period is governed by. Now, Lordship, kindly see, when month by month tenancy comes into play, in absence of a contract or local law. So when there is no contract,
You already argued,
yes,
sir,
Lord.
on
I-
that day.
I
You are in the examination of the witness on the deposition. You
Yes,
last occasion you referring the questions of the PW1.
Yes, Lord. Yes,
This
Lord.
law point you already argued. You already argued. And I have
So,
taken note of
what
it.
I wanted to show from that cross examination, cross. PW. I was from the cross, and what I want to endeavor to show from the cross and from the pleadings,
Yes.
that since in absence of a contract, when there is a lease, it will be month by month. But since the contract has been admitted by the parties, if your lordship kindly come to question number 68.
Of Krishna Bayani?
Yes, lordship, there was only one witness.
Yes, 68.
So, lordship, kindly see question number 68 first. Can you produce any document in respect of the fate of the suit on the next date? I have mentioned earlier that it is a very old record and they are not pertinent to the company. I want to add there that the tenancy agreement was entered into a national this and are paying rent. They surrendered the possession of the tenancy to the plaintiff. So, lordship, this second part, they surrendered the possession, is not correct, because I all along, prior to them, I was there. My predecessor were there. So surrender of possession is not there. Now, so far as why I asked him what is the fate of the suit, because if the fate of the suit, he cannot say that that suit is no more in existence, then lordship, we probably will not come out of the earlier Act 56. It will remain as a pending. So if your lordship kindly see 63 now.
Yes.
When did you file the suit such and such? 83. That I cannot remember at the moment. It was a very old matter. I have already answered the question in I-64. Can you apprise the Honorable Court what is the fate of the suit being number such and such? I have already answered this question earlier and the dispute was settled by the parties.
Yes.
So, lordship, what is emanating from him is there was a litigation, there was a settlement, there was a terms and contract, and the terms and conduct he has accepted. So there is no ambiguity that the agreement which was, now lordship, the general lawyers, the agreement cannot be looked into if it is not properly registered. However, there is no bar to look into it as a collateral document. Most of the judgment we will find that unless it is registered, the court cannot look into it.
Yes.
But in my case, lordship,
Yes.
but in my case is different. My case, the document is being exhibited with or without objection. With objection, obviously, but document has been exhibited. Now, lordship, when a document is exhibited, then lordship, we cannot fall back on 35 and 36. So now it is an exhibited document, and in cross he has accepted the terms. So the terms binds on the parties. It is an exhibited document. Now, lordship, kindly turn to question number 70.
Yes. Yes.
Now, lordship, in question number 70, I asked him which terms or the condition I have violated. He said, I cannot answer this.
Yes.
Now, kindly turn to page 71, 72. Question number 71, 72.
Yes.
Mr. Bihani, what is the corporation tax rate for the premises which was occupied by the defendant here? The municipal tax rate is 40% of the rent plus there is a commercial surcharge such and such. Did you serve any notice or ever have you raised any invoice demanding this charge in respect of the property which is in possession of the defendant? He said yes. Can you identify the demand notice or the invoice from the record of the court wherein you have demanded this from the present defendant which was in possession of the suit property? It may not be in the court record, but earlier we have given notice not at the time of filing suit. So the very question is what I submitted before your lordship is, his entire case stands that once a new law has come, so the effect of that agreement goes, and it is only 106. So it is month by month tenancy and notice. Even he choose not to indicate my any breach. Now, lordship, kindly turn to is it your lordship kindly turn to question number 74 and 76.
Yes.
Sorry.
Yes.
79 rather.
Yes.
After the month of 2008, lordship kindly see,
Yes.
when I argued one point last time that I have tendered the month by month tenancy, then lordship said there was a court order protected them from taking. Then lordship, I immediately asked him question. After serving of notice, next month also I have tendered you. Whether did you receive the money after August 2008, because he served me the notice. Lordship will find that at 79. After the month of August 2008, while you received the amount from the defendant, did you protest, demur in respect of the money which the defendant tendered to you in lieu of their possession in respect of the suit property? He said, I have to check. Is it your evidence that the demand from the defendant can be raised by the plaintiff beyond the term which are mentioned in clause K of the deeds? Then he said, yes. Kindly indicate from the document which are on record to show that you are entitled to demand any charges or cost in respect of the premises which are in possession of this. This is a subject of law. Counsel will answer at the time of argument. So he did not identify the thing. I am suggesting you to the premises maintained by the till that I disagree. Do you have any document to show or suggest that the premises is maintained? So the maintenance part I have taken, tax part I have taken. Now, lordship, 85. This is very important. Mr. Bihani, is it a fact that the defendant has paid you rent in terms of the clause 3 of your agreement with the defendant paid rent prior to the termination of the tenancy and not thereafter? So now kindly see 85 and that 79 is completely two different answers on two different dates. Did you receive any money from the defendant after issuance of the termination notice? The defendant tendered the rent after the termination notice was served, which was refused to accept and returned the check to the defendant. Did you receive any charge from the tenant of the left premises? The question is not clear. Did you receive any charges or occupational charges for the premises in question from the defendant? Herein, after issuance of your termination notice, yes, we have received occupational charge from the defendant pursuant to the Honorable High Court order. Now, lordship, kindly turn to question number 100. Sorry, question number 93, lordship.
Yes.
Have you produced any document before the court in law in support of your duty stipulated in such and such? I have to check. 91. Is it correct to say that the present defendant has complied with the terms and condition of clause 7 of your exhibit A? They said yes. So, lordship, my obligation under that agreement I have fulfilled. From the cross-examination, I have shown that there was no demand which I could not pay. That means the corporation tax demand. So far as the rent is concerned, he first said that refused, then he said under court order I received, but ultimately he accepted that till the date I left the possession, no money is left over. Now, Lordship, kindly see. (101).
Yes.
Sorry, 100. After the defendant vacated your premises, did you comply with clause 5 of the exhibited document? Clause 5 is holding the security deposit. Since the tenant has not vacated and handed over the possession, we could not comply the clause 5 of the tenancy agreement. Witness then correct himself and says, of course, the defendant has vacated the premises, but not cleared the payment of corporation tax and other dues.
Yes.
So, Lordship, kindly see. First, he said that I have not raised any bill for the corporation tax. Then I said that, are you honoring that agreement till date? He said yes. Then I said, did you receive all payment? He said yes. Then I said, are you still holding the security deposit? He says, yes, I am holding. I will give an adjustment with that. So, Lordship, today, he's from the cross-examination. I have shown that the parties have given a true effect of the agreement between the parties. Now, once the parties have given agreement between the parties, by operation of law, it will not fall back to month by month. It will fall back to a 11-month to an 11-month lease, which is unregisterable lease is permissible, and the terms and condition will.
Yes.
So the determination or termination clause has to be related either with the efflux of time, that means that 11 months, which 11 months started, either it has to be a 11 months time or in between for the breach. This is my single sentence submission in the matter.
Why?
Because parties said we agreed to the agreement. Unregistered agreement is good and valid for 11 months. So, Lordship, that agreement was going on between the parties. So now he has to say that no, it is not 11 months. It will become month by month. Because the evidence suggests and my defense suggests that this particular document.
What the division bench said.
Division bench.
What in appeal? What the court said.
No, that was absolutely different. There was a decree by consent.
Correct.
So decree, then we argued there that the consent by a learned counsel is not sufficient. Then the division bench says, all right, you secure the money. We secured the money and month by month we also paid. And then degree set aside, and now we are before your lordship on a contest basis. Because that was by a concession, by a council, that too not by this. Parties said that we will vacate the premises, like here also, before the decree we vacated. But then at that point of time, there was no instruction, or council cannot enter into a oral agreement with the council of other side to come that this is the terms and condition on which we will. That was precisely happened with my earlier counsel. So the matter gone up to the division. First we make an application for recall of that. That court said, no, I will not recall. Then it gone to the division bench, and division bench says, yes, if the council consent, I cannot hold a decree. Okay. So that was satisfied. So finding on merit on this point was not there. This is the first time I am arguing before you.
Okay.
So, lordship, the thing is, when 11 months is permissible, then he has to make out a clear case that no, 11 months is not applicable here. it will turn to a month by. Now, Lordship, kindly see the language of the plaint. How the plaint they have done. Paragraph 2. And I would request your Lordship to take that exhibit number 3 as well, side by side. It is annexed to the plaint as well, Lordship. Annexure A to the plaint.
Yes.
By and under an agreement dated 7th May 1984, the plaintiff let out the defendant a portion of the second floor such and such. The said more fully described in this. The copy of the agreement of 7th May 1884 is annexed. It will appear from the agreement dated that by virtue the defendant agreed to pay plaintiff monthly rental of auto for the premises at such and such rate, increased by 10% 3 years, subsistence of the tenancy. It is further agreed by the defendant to pay and reimburse the defendant occupier's share, municipal tax including surcharge. Lordship, I have shown that they have not raised bid imposed earlier by the central government, state government, corporation tax, such as. It will further appear that the agreement dated under such and such agreed to pay to the plaintiff a maintenance charge of this. In terms of the said agreement, landowner was increased such and such everything. As much as the defendant tenancy of the was a tenancy from month to month, and with repealing of this West Bengal premises tenancy, is tenancy of the premises come to be governed by the property in view of the rent payable, and this, as such, the plaintiff become entitled to terminate upon notice. So, Lordship, this paragraph 6 is his cause of action.
Yes.
Kindly see how I have dealt this paragraph 6. Lordship, kindly turn to my para 12.
Yes.
The defendant denies that after repealing of the West Bengal this, the tenancy of this defendant is governed by this, in view of the rent payable by the defendant as well. The defendant also denies that the tenant, pursuant to repealing of this act, has become entitled to terminate the tenancy by 15 days notice as alleged under this. Now, Lordship, with this, we will read my paragraph because there is the bare denial. Kindly read my paragraph 6.
Yes.
The agreement dated was entered into by and between the parties and the defendant in terms of the compromise of the suit number this, wherein it has been specifically recorded the tenancy in favor of the defendant shall be purely a monthly tenancy with a meaning of the West Bengal premises 19. In view of the matter, the statutory modification and the operation of this does not bring the tenancy of different out of that.
Yes.
The purported notice for which the tenancy of the defendant and is sought to be terminated is bad in law, and no termination of the defendant tenancy can take place. So, Lordship, what I am saying is the protection under 1956 Act was that its protection continues till the agreement goes. By operation of law, that protection will reduce to 11 months. Because if we read 106, then it says, in absence of a contract.
Yes.
So, my protection will remain up to 11 months for that particular. So, Lordship, if we calculate this, then Lordship, it will not come from May 84. It will continue. So, similarly, the month started from May
7 May 84.
7th May 1984. which was served in July 2008, because 11 months, every month it will reduce one. So the July 2008, treating me as a monthly tenant for the month of July, August, or June, July, August, whatever, will not hold.
Okay.
Whenever you want to terminate, I will get a protection of my 11 months.
Okay.
Now, Lordship, kindly come back to the plaint, Lordship. As such, not being desirous to further continuance of the tenancy, defendant's tenancy by a notice dated 19 July under section 106, the plaintiff through its advocate terminate the defendant's tenancy of the suit with the expiry of month of 2008 and called upon the defendant to vacate the peaceful possession of said on the expiry of the plaint. A copy of the said notice is. Now, Lordship, kindly turn to Annexure A and Annexure B. Annexure A, Lordship, has
Yes.
under instruction from and on behalf of the above client, we write, by an agreement dated such and such made between our client and yourself, our client inducted you as a monthly tenant with effect from this such and such and continued a floor place of other. The such and such a monthly tenant of rate and such and such. It is agreed by and between our client and yourself that the monthly rent from payable time to time will 10% increase such. In accordance with the agreement, the monthly rent in respect of the tenant and premises was increased to every year by 10%, and after such increment, the monthly rent is 1,56,030, and the maintenance charges for this. The West Bengal premises tenancy was repealed, and pursuant to the enactment of the West Bengal premises tenancy, which came into force, further by reason of the provision of section 3F of West Bengal premises tenancy, this same has no application to the tenanted premises. In such circumstances, you are a monthly tenant of the tenant premises, which is terminable by our 15 days notice expiring of this. So what they are trying to do is, they are trying to say that since you are now, there also I was a monthly tenant. Here is also a monthly tenant. There's no dispute on that. Protection and breach. In the previous situation, I had a protection that unless I breach, it will continue because there was no efflux. And here he says that I have a right to discontinue even without your breach.
Okay.
So, Lordship, the only moot question before your Lordship, that this agreement, when accepted by the parties, at the time of issuing termination notice,
Yes.
framing the plaint,
Yes.
and in deposition,
Yes.
whether they can wriggle out of the terms of the contract in view of this amendment. Whether this amendment will make me a situation of without protection.
Okay.
Answer to this is, my answer to this is, this all terms will now, because lease is a special type of contract. So this lease, and read with the section that in absence of a contract, these all protections I have will be attached to the lease either 11 months or month by month.
Okay. Got your point. Yes, next.
That is the only precise point I have.
Okay.
I do not have any other point. And so far as termination notice is concerned, I have all along in my written statement, if your lordship kindly turn to para 8.
No ground of termination.
So I always challenged that termination notice is bad.
Yes. That's all.
I have finished. Now, lordship kindly see paragraph 8, cause of action.
Yes.
Only I will show one.
Yes.
They said, lordship, July they have issued notice. They gave me 1 calendar month, as if that old act. And then they are saying expiry of month of August. Lordship has got it?
Yes.
Now, lordship kindly see the agreement.
No, notice third upon the issuance and delivery on itna registered put into evidence the defendant endorses the acknowledgement. Right.
Lordship, when it is only 106, I can give you notice.
Correct.
5th of this month.
Yes.
And on 21st of this month, I can file a suit.
Correct. 15 years.
So only wait for 15 days
Correct.
within the month.
Correct.
Now, lordship, if you see the termination notice or eviction notice under 56 Act or under 1997 Act, 97 Act, lordship will find 1 calendar month. So even if he receives the notice 20th of this month, it will not from 20 to next month 20, not 30 days notice. Notice is calendar month. So I have to, if I give a notice in month of August, then he receive in month of August, say 23rd he receives. Then lordship, 23rd of September will not my cause of action. Not 30 days, 1 calendar month.
No, but the notice is 106 under the TP 82 Act. TP Act, not under the 10.
What I am saying is nomenclature. I will formulate my this second point. So under the 97 Act or under the 56 Act, the provision is...
That is 130 days.
No, not 30 days. 1 calendar month.
Correct, 1 calendar month.
So even if it reaches him 20th of this month, 21st of next month is not my cause of action. Calendar month means he will get the entire September calendar month, and then in October I will have a cause of action. So when they serve the notice, they said that you are not. Kindly see calendar month notice is there. July he has given. July I have received. Kindly see. That's what I have taken your lordship to the cause of action part. So basically, even at the time of giving me termination notice, they followed that particular principle. And we have to see section 6, eviction notice. Sir, I admitted, my lord, that this was a monthly tenancy. So his cause of action started from, that is his own case. He is making out his own case. You see, July he is serving me the notice. Lordship, I have placed that paragraph, Lordship. 19th July.
Yes.
Which I received on 22nd July according to them. So 22nd August could be the, sorry, 15 days is, 7th of August is the 15 days. But he is not taking 15 days.
Expiry of 1 month.
So now if I, now expiry of not 1 month, my lord.
Kindly see para 8, para 9. Para 9 of the plaint. para 9 of the plaint, their case 8 is the notice received on 22nd. Despite having received the notice dated 19 July, respectively, the defendant has failed to vacate and hand over the peaceful possession of the premises.
Sir, expiry of 1 month.
Correct.
Not 1 month, 1 calendar month.
1 month of what is written in the plaint, 1 month of August 2008. Kindly read the paragraph 9.
I'm reading, my lord.
Yes, read.
Despite having received the said notice, 19th July, on 21st July and 22nd July.
Correct.
Pause here for a moment. Sir, if it is pure 106, then only 15 days. From 22nd to 31st, 8 days, and 7th of next month.
8th of August, yes.
Respectively. Vacate. So I failed and neglected to vacate from 8th of next month. 15 days is over on 7th.
Correct.
So my default will start from
8th of August.
Lordship, 15 days notice.
Correct.
But kindly see, when my default they are holding, after 1 calendar month, that is the month of August. Because I received this side of July, so the August is the calendar month. So my default starts from 1st September according to them. So moment they give me 1 calendar month, that means they are honoring the statutory provision of 1956 Act or 97 Act, where is the 1 calendar month. May I just read out the language of the statute, calendar month language. Notwithstanding contained in any other law for the time of the suit for recovery or possession of any premises on the ground aforesaid, except mentioned in this clause A1, shall be instituted by landlord unless he gives to the tenant 1 month's notice expiring with the month of tenancy. Lordship, kindly see the language. May I hand over this?
1 or more following grounds. Just in favor of the landlord. Yes, 1 month. Correct.
So if it is, then Lordship 108 comes. If he says and condones it, after 15 days, my thing is over. So moment he accepts me after that 15 days notice, then Lordship transfer the property. Lordship, then kindly see, moment he accepts the rent or accepts me beyond 15 days after serving the notice, then Lordship 100 and then Lordship immediately the waiver will come, then waiver of forfeitures and 112 and 115 will come. So Lordship, where he is making his case is, if he stick to his case of 106 only, then Lordship on August 8th, I am holding the possession. But here he is saying, no, you are only wrong from September. So moment he gives me that space, so either the notice become bad or he accepts the terms of the earlier contract. This is my precise point I want to follow.
So as per your contention, he has issued the notice in the month of July, 22nd you are received. As per 106, 15 days is over. 15 days is over. If it is considered as 22nd of July you received, the 15 days it is 7th of August. 7th of August.
Holding illegal possession from
8th of August you are holding the illegal possession. As per 106. Correct.
Right. If he goes by strictly 106.
Now, if we read the paragraph 9 of the plaint, they have considered the 1 month of August 2008. So it's
after expiry of August 2008.
That's why 1 month of the August.
That means
so September onwards you are the illegal
first, right. So that means from 8th of August to 31st of August,
you are in illegal possession.
I am in legal possession.
So your contention.
So if I am in legal possession from that period, after the notice of termination, sir.
106 gone.
then 106 goes.
It is your contents.
And this has to be read with his admission in the cross-examination
Yes, yes,
that I am honoring this.
yes.
মানে আপনি আমাকে থামানোর এই উদ্দেশ্যে আমি একটা লাইন বললেও আমারটা শেষ হয়। আমার এই দুটোই
Yes. Yes. Next.
Next is section 111, third part.
Yes.
Lordship, kindly see the determination of the lease can be on a flux of time or happening of a condition.
Yes. Yes.
Now, Lordship, kindly see hundred and 50.
Yes. Yes. Surrender and forfeiture.
Yes. Vis-a-vis 130. A notice given under 111, Lordship, this is not a provision with 106. That is not there because 106 with unregistered.
Correct.
But to show how the waiver will come into picture for an unregistered deed, for a registered deed, that chronology I am drawing from 130. A notice given under 111 clause H is waived with the express or implied consent of the person to whom it is given by any act or part of the given is showing an intention to treat the lease as subsistent.
Accepting.
111 is a registered.
Correct.
111 goes for a register. But then the waiver in a register is 113. And then 113 gives us an idea that how that termination notice can be given up.
Correct.
By other of the parties. So there they says, because akin to 113, there is no provision which will govern section 106. So I am trying to take a chronology from 113 and trying to show that notice under 106 will be also, principally, will be also governed. Generally, I can say waiver, acquisition, estoppels, those general. But this act says, when there you have given a notice, but by your act you can condone it. So what is that act? A notice given under 111 clause such and such, implied with the express or implied consent of a person to whom it is given, comma, by any act on the part of the person giving it, showing an intention to treat the lease as a subsisting. So that means once he has given me a notice, from 8th of August till 31st of August, he intend to
waive the
continue
note. So waive the notice under 106.
Right.
Your contention is there.
Yes.
So that's why.
So that's why I challenge the notice is bad. There is a shortfall in the notice. Notice he has waived.
Yes.
And if he has waived that notice and then also he accepted the terms, I handed over the
continuous.
then whether the termination was correct or not. Because that is the issue on which Lordship we are arguing.
That is the only issue here.
So my factual argument and on the statute is absolutely over. I will only rely on one judgment. Lordship, that today we don't have, no, Lordship.
Not having.
I will supply them a copy in advance, and that day I will not argue before your Lordship. Except placing that judgment, Lordship, facts and the law I have.
For 4 days.
Sir, আমার কেসটা কিন্তু খুব বলতে নেই খারাপই ছিল. I tried to make out something of nothing, but then
That's why the tenant easily not vacate. Lease for the tenant.
Yes, vacated.
I have.
Oh, yeah.
My lord will keep it any day subject to my lord's pleasure. But I take it my learned friend will take 5 minutes that day because whatever time is left, I will finish that day.
Yes, yes.
And counsel for the defendant has argued at length. I concluded his argument with regard to the facts of the case. Only submitted, he will rely upon one judgment after giving the advance copy to the learned counsel for the plaintiff. In view of the above, is adjourned. Let the matter. Give the date. 8 September, 3 p.m.
Very well.
I'm deeply.
Very grateful.
Thank you. Yes.
Lordship, I did not get any the proposition which I want to say. I did not get any of the reported judgment of this. So still I tried to make.
Okay, let us see. Yes.
Before my lord, my lord, is item number 14 of today's list, my lord, is fixed at 14. It was fixed at 3:45, my lord. But the interim order is expiring today, my lord.
Today?
Today.
I'm for the defendant, Lordship. I'm not opposing, my lord. My lord, kindly fix a date, my lord.
Though the matter is specially fixed today at 3:45 p.m., but this court is not, but the matter is not taken up for hearing. Accordingly, case adjourned. Learned counsel for the plaintiff prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order is extended. कब पर रखेगा इसका डेट है कुछ? 9 September at 3 p.m. उसको तो दी 8 September तो 9 September at 3 p.m. Interim order is extended till 9 September or until further order, whichever is earlier.
Deeply obliged.
Item number 13, which is fixed today, Miller, at 3 p.m. for witness action. I had mentioned this matter yesterday at the time of rising, Miller.
Yes.
Miller, in the meantime, the company, Miller, has gone into liquidation. There is a resolution professional, Miller, who has been appointed. The difficulty which we are facing, Miller, is that documentation, Miller, is there, but it is difficult to, Miller, coordinate. Lordship knows once IRP is appointed, becomes difficult. He takes in charge of the company. But kindly keeps this matter in November, so that, Miller, JBD can be prepared and AOE can be prepared, affidavit of evidence can be prepared.
Though the matter is specially fixed today at 3 p.m., but the counsel for the plaintiff 3 p.m., but the counsel for the plaintiff prays for time. According case is adjourned. Let the matter appear on November.
Let it appear in the monthly list of November, because I will file my affidavit of evidence, then take time.
Let the matter appear in the combined monthly list of November 20.
I'm deeply obliged, Miller.
But item number 36 of today's list, well, the
Yes.
interim order is expiring today. I'm mentioning upon notice.
Which for the other side?
But Mr. Hussain and
Flint
Mr. Dotto, Rajesh, the Flint group, yes.
As per the prayer 36, as per the prayer made by the counsel for the plaintiff, interim order is extended till 17th September 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Great.
My lord, item number 23, my lord.
Yes.
The interim order is expiring.
Item number?
23, your lordship.
23.
It's expiring on 22nd, your lordship. But the matter
22nd.
is 22nd. Should I mention it?
22nd, come on, 22nd.
My lord, one indulgence, my lord, as well. Kindly, my lord, last item number 14, my lord. My lord, kindly fixed on 9th of September. I'm just informed, my lord, Mr. Shakoshan, senior advocate, is arguing the matter. He's not available on 9 to 17. So it's kindly.
You are there.
Their application, Lordship.
No,
I don't have any difficulty.
There's our application of injunction. There's another 2 application pending, which is
Filed
for
by
the
one
adding.
of the,
So it appearing, Mr. Train will argue matter.
Yes.
So what is to fix another date?
Please, kindly, my lord.
हाँ? वो 9 नहीं रहेगा वो 8 September.
Fine, absolutely.
उसको जो फर्स्ट वाला ना 8 September 3:45
I'm
कर.
deeply grateful, man. Grateful.
Any other entry mode? अच्छा कोई आने से भी ना उनको बोल देना हमको फाइल दे देना कल साइन कर